To everyone at the conference table, if you are running this meeting on your own laptop, please mute your microphone and silence your speakers to avoid feedback. If you wish to speak, please turn on your conference table microphone by flipping up the switch and speaking into the microphone. When you are finished speaking, please flip down your microphone switch to be muted. Madam Chair, in a moment, the public participating remotely will see and hear the meeting. You'll see the welcome screen. When that disappears, you may turn on your microphone and begin the meeting. I don't know why that screen is still on. I did the end practice session. Yes. Yes, I apologize.
Yeah.
Yep.
I was going to ask you, do you want to see me?
No. Yes, I apologize.
Okay.
That I missed a button. I'm sorry. There we go.
Are we live? Okay. All right. Hi, everyone. This is Kelly Mitchell. I'm the chair of the Sentencing Guidelines Commission. This is July 22nd, 2021, and I will open the meeting. Everyone can hear me okay? Is that right? Okay, I got a nod. Thank you. We can see some of you on the screen. We have a couple of people located here in the meeting room. So forgive me if it takes me a little bit longer today to sort of figure out who to call on and in what order. It'll just, I'll have to get used to this sort of dual meeting format. All right. I just want to remind everyone that we are working on the remote meeting rules, the rules that are, that always existed, that allowed us to have folks attend meetings remotely if necessary, if we gave the proper notice ahead of time. So we are working under that. And because of that, since not everybody is in the room with us today, we do need to continue with the roll call voting so that to make sure that everyone on the commission and everyone in the public is aware of what the actual vote was. So I just want to let you know that we will continue with that process. And with that, I'm going to ask Nate to go ahead and call the roll.
Roll call. Estrada?
Present.
Estrada present. Blakey? Blakey absent. Dietzen?
Present.
Dietzen present. Honnold?
Present.
Honnold present. Hansi absent. Ladd?
Present.
Ladd present. Larkin?
Present.
Larkin present. Mark?
Present.
Mark present. Middlebrook?
Present.
Middlebrook present. Schnell? Schnell absent. Chair Mitchell?
Present.
Chair Mitchell present. Madam Chair, there are 8 members present, 3 members absent.
And with that, we have a quorum today. Thank you. And also, for those who are in the room, I just wanted to let you know that the little red button in front of you is sort of like unmuting yourself when you were on WebEx. Like you do need to unmute and mute every time so that everybody on the call today can hear you, both the other members of the commission and members of the public who might be listening in today. Okay, so the next item is approval of the agenda, and I would entertain a motion to approve the agenda.
So moved.
Commissioner Larkin makes that motion. Do we have a second? And Commissioner Middlebrook seconds. Second. Any discussion on the agenda? Hearing none, we will take the roll on that.
To the Larkin motion to approve the agenda, Estrada?
Yes.
Estrada?
Yes.
Estrada, yes. Blakey? Blakey, absent. Dietzen?
Yes.
Dietzen, yes. Honold?
Yes.
Honold, yes. Hansi? Hansi, absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell, absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the agenda is approved unanimously. Next item on the agenda is approval of the draft meeting minutes from June 3rd, 2021. You should have all received those last Thursday or last Wednesday, actually, is when everything was sent out. And I'll entertain a motion to approve the minutes.
Ladd moves.
Commissioner Ladd makes that motion. Do we have a second?
Second, Larkin.
Second from Commissioner Larkin. Thank you. Any discussion? Hearing none, let's read the roll.
To the Ladd motion to approve the June meeting minutes, Estrada?
Yes.
Estrada, yes. Blakey? Blakey, absent. Dietzen?
Yes.
Dietzen, yes. Honold?
Yes.
Honold, yes. Hansi? Hansi, absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes. Yes.
Middlebrook, yes. Schnell? Schnell, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the minutes are approved unanimously. Okay, well, we have a busy schedule ahead of us today. We are going to be reviewing all of the laws that were passed during the 2021 special session. And we have a lot of ranking decisions to make today. So let's bear with me as we work through this. If it's looking like the meeting is going to be lengthy, then I will call for a break, maybe about, an hour and a half into it. If we're moving along fine, then maybe we'll just go for the 2 hours and be done with it. Let's move on to item 4, which is the first special session amendments to crime laws affecting the guidelines.
Thank you, Madam Chair. Let me pull up the presentation here. So the materials that we'll be working off of today are the materials that are posted on the website and the materials that I sent to the commission last Friday afternoon. To make matters more confusing, I sent 2 emails on Friday afternoon because I found a mistake. So this is the later of the 2 emails. I think it was sent around 5:30, and I resent all the commission meeting materials. So that's the email that you want to be working off of, members of the commission. If you're looking at the emails, otherwise for members of the public, we're just working off of the materials that were sent out. For members in the room, if I'm going to be working off of a PowerPoint, which is item 4B on your agenda. So it's going to look like this on the screen. Can we make that full screen, Linda? The PowerPoint. So it's a little bit hard to see in this room, even when Linda gets it to be full screen. So so while she's working on that, you may want to have your computers on and be following the meeting in WebEx, just to make it happen. But I think I think you can make that full screen somehow.
Yeah, I'm wondering, Linda, if it's possible to leave them across the top, but just sort of stretch that, get rid of us. Because otherwise I won't be able to see who would like to speak on an item.
What are the layout options for you there?
Yeah.
It's in full screen view, and because it's on camera, it's going to only provide it that large.
Well, we were able to get it full screen in the test. Can you show active speaker with shared content? Maybe that will help. Well,
That's all right. I don't need it.
give
It's
it
all
the
right.
chair while we're following along, but okay, so I'm going to start with the presentation. This should be visible to people online at any rate. So I guess by way of background, when we met in May, we knew that the legislature was considering some changes to criminal law. And we knew that there was some consensus on what some of those should be, meaning that both the House and the Senate had agreed to certain changes. So we took advantage of that knowledge in May to run through a number of changes in some detail with respect to criminal sexual conduct and just a minute, please. Linda, are you fiddling with the sentence settings to see if you can?
I can tell you that I cannot get that any larger than that.
Okay. Jill, can you maybe see if you can lend a hand? So we looked in May at quite a bit of detail, especially on the criminal sexual conduct changes that were being considered at that time. Then in June, we looked at pretty much all proposals that were being given any consideration by either the House or the Senate at the time that the regular session ended, anticipating that there would be a late June special session and that some or all of those proposals might be adopted. And as it turned out, a number of those proposals were adopted. So essentially what we're going to be looking at is almost all review of what we looked at in May and June. There were some small changes to some of the proposals that had been placed out there for consideration. And there's one new proposal that we really haven't talked about at all, having to do with first-degree assault. I mentioned it in passing at one point, but we've never really discussed it in the commission meeting. But the good news is that everything that we're looking at today has, to some degree or another, been discussed by the commission, except for first-degree assault. The other things I'd like to do to save time are basically to assume the following four things. Anytime somebody makes a motion, first, we're going to assume for purposes of shorthand that each modification is subject to a public hearing on September 1st. And second, each modification is subject to the guidelines, the commission's final action on September 9th, 2021, which is your next meeting. A quorum will also be required for that meeting. Third, that the specified modification effective date is September 15th, 2021 to apply as provided in section 3G of the sentencing guidelines, which provides that the modifications will apply to offenders whose date of offense is on or after September 15th. So 2 points to make on that. The legislature did, well, I should say the public safety committees did follow the commission's recommendation to date all the effective dates on September 15th. So that'll make things pretty clean. We'll talk about that in a future agenda item in more detail. The second point I'd like to make about that is for those who've been around since the Drug Sentencing Reform Act, you know that there are some issues with effective dates and the amelioration doctrine. If there's a change in the law that mitigates punishment, we don't have to worry about that this year. There were no changes in the law that mitigate punishment. This was definitely I would say a more normal legislative year in that all punishments are being increased or remaining the same. And fourth, and I assume that the commission will not be mitigating any punishment. But of course, you might choose to do something different than that, but that's my assumption. And fourth, the motion includes the staff drafted guidelines modification language associated with the motion. So if the motion is, make conforming technical changes, we will understand that what you mean is you want to make the conforming technical changes that staff has already drafted and provided in the handout 4A1 version 3. So we're going to just divide this into two sections, changes to sex offenses, which includes child prostitution for these purposes, even though the commission does not consider child prostitution to be a sex offense. But because the age issues are so similar, we're lumping it under sex offenses. And B, changes to everything else. So looking at changes to sex offenses, the first change, and we've discussed this, is changes to criminal sexual conduct offenses involving force. Can't get that full screen. Well, hopefully everybody in the room is following along. So, don't have any members of the public, but I'll just say it is illegible. I can see it on my screen, but so the act redefines force. It doesn't really change the definition that much, but it does reorganize it so that force with bodily harm is carved out from other types of force, which are involve threats and attempts. And it takes these where bodily harm is actually inflicted, and it moves those force offenses from criminal sexual conduct in the 3rd degree and criminal sexual conduct in the 4th degree, depending on whether there's penetration or contact, to criminal sexual conduct in the 1st degree or criminal sexual conduct in the 2nd degree, depending on whether there's penetration or contact. It also assigns the 144-month and 90-month minimums to these new offenses, which the guidelines take as basically being statutory presumptive minimum sentences. So that's not remarkable with respect to Crim Sex 1, because all criminal sexual conduct in the 1st degree offenses have that 144-month mandatory minimum. But it is notable with respect to Crim Sex 2 because not all Crim Sex 2 offenses have that 90-month mandatory minimum. So, and that definitely weighs into the staff's recommendations, which we'll get to in a moment. It also restructures force and coercion offenses so that whereas before force and coercion pretty much always appeared together, now they're pretty much always separated. So coercion is a standalone offense, and then force with it, bodily harm inflicted is a standalone offense in Crim Sex 1 and 2, and then force where it's just attempts or threats is a standalone offense in Crim Sex 3 and 4. Be happy to answer any questions about that, but that is pretty much a review of what we discussed in May and June. So the staff recommended response, and this is all on pages 2 and 3 of your handout for A1 version 3. So the staff recommended response is to rank the new force offenses at severity level A and severity level B. And that severity level B is consistent with how other Crim Sex 2 offenses that have that 90-month presumptive statutory minimum are also ranked at severity level B. And then to add the new Crim Sex 1 and 2 offenses to the severe violent offense list and maintain existing rankings for other restructured force and coercion offenses. And we'll talk about exactly how that, well, we display how that actually happens at the end of section A2 in your handout. We don't actually display that in your handout at the end of section A1. So at this point, Madam Chair, I guess, I don't know how you want to do the motions. My thought is I suppose you could just do one blanket motion at the end to adopt all staff recommendations, but I think that's unlikely. The other way you could do it is a commission member could make a motion to adopt staff recommendations with respect to changes to CSE offenses involving force, or item A1 under the handout, or however you want to look at it, or we could take each of the bullet points as a standalone motion. So I guess it's up to the chair and the members of the commission how they want to proceed with motions.
Yeah, I think that for ease of application today, for each offense or for each decision point, we have a bulleted list of staff recommendations. And I think that what we'd be looking for would be a motion to cover either those recommendations, like motion to adopt the recommendations, or if you have a slight tweak to one of those, then say that as part of the motion. Does that make sense to everyone? I think if we kind of do these in sets, that we'll get through it more easily. Because I would imagine there might be times where somebody might not agree with everything that's in the bulleted list.
Well, I would assume so.
Yeah.
These are just recommendations.
Right.
You're the commission, I'm not.
So let's take it topic by topic. Is there anyone who would like to make a motion regarding these the changes? Sorry, what do they call it? Changes to criminal sexual conduct offenses involving force. And I can't see everybody, so I don't know if anyone's trying to raise their hand or, Judge Larkin? Okay, that's helpful. Is Judge Larkin with?
A quick question first. As I understand the recommendation, it essentially ranks these offenses consistent with how they are ranked now.
Go ahead, Nate.
Well, that is true with respect to the coercion offenses, and that's true with respect to force offenses not involving infliction of bodily harm. So where there's merely an attempt or a threat, then that is a true statement. However, with respect to force where bodily harm is inflicted, that is being elevated by the legislature to Crim Sex 1 and 2. So there is no ranking for those offenses now. They're being ranked consistent with other offenses that have those 144 and 90-month minimums, statutory minimums.
So that's the first two bullets under the staff recommendation, that the new CSD first degree force offense involving infliction of bodily harm is ranked at severity level A. The new second degree force offense involving infliction of bodily harm is ranked at severity level B. Oh, and there's also a new, oh, yeah.
And I could refresh the commission's memory with our May meeting to just, so what we discussed in May was the fact that there was a constitutional issue that was raised with respect to classifying criminal sexual conduct involving force as a Crim Sex 3 and criminal sexual conduct with force and personal injury as a Crim Sex 1. And the problem was that one way of defining force was infliction of bodily harm, and one way of defining personal injury was infliction of bodily harm. So essentially, you could, by committing one of these crimes and inflicting bodily harm, be charged really either as a Crim Sex 1 or a Crim Sex 3, depending on the prosecutor's discretion, because bodily harm was a way of getting to either force or personal injury. So what the legislature is trying to do here is avoid that constitutional potential problem. I don't know that it's been ruled as being a problem at a statewide appellate court, but it has been ruled as a problem, at least at a district court level. And by problem, I mean a constitutional problem because the same crime can be charged out two different ways. So to avoid that, the legislature took force with bodily harm and made it a Crim Sex 1 if sexual penetration were involved, or Crim Sex 2 if sexual contact were involved. I don't know if that jars anybody's memory.
Commissioner Larkin.
Yeah, so I'm just trying to simplify this as much as I can. So for crimes that we already had, the sentences staying the same, but for this new crime, which involves force resulting in bodily harm, we're raising the ranking for those offenses. That's the proposal. In other words.
That is correct.
That is correct. Then I move to adopt the proposal as submitted by staff.
Okay, so we have a motion by
Second.
Commissioner Larkin. Do we have a second?
Second.
Commissioner Dietzen seconds. Any discussion on the motion? All right. I don't think we have any disagreement here. Hearing none, please call the roll.
To the Larkin motion to adopt the staff recommended changes in section A1 involving changes to criminal sexual conduct offenses involving force. Estrada?
Yes.
Estrada, yes. Blakey? Blakey absent. Dietzen?
Yes.
Dietzen, yes. Honold?
Yes.
Honold, yes. Hansi? Hansi absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor and no votes opposed.
And with that, the motion passes unanimously. So we'll move on to item 2.
Thank you, Madam Chair. So item A2 is involving reorganization of criminal sexual conduct offenses by age and occupation and just in general. And we discussed this, this is all pretty much consistent. There was I think a mistake that they made with respect to the offenses that are now ranked at severity level G, and they corrected that mistake. But essentially what it does is it reduces most age gaps from 48 months to 38 months. What we mean by an age gap is the minimum amount of distance in age that the perpetrator and the victim have to have from each other for these age offenses to qualify as crimes. It also changes the age threshold for crim sex 1 and 2 offenses from under 13 to under 14. So if an adult has sex with a 13-year-old under current law, that would be, assuming no other circumstances present, under current law, that would be a crim sex 3 or crim sex 4 if it were contact. After September 15th, that would be a crim sex 1 or crim sex 2 if it were contact rather than penetration. The act also consolidates a number of offenses that are separately listed under current law, all related to somebody's occupation and sort of a power imbalance that exists due to that occupation. Examples are psychotherapists, police officers, corrections officers, special needs bus drivers, that sort of thing. It lumps them all under prohibited occupational relationships. It also adds 2 new prohibited occupational relationships to the offense list. And we discussed all these at previous meetings. But essentially, these are all now lumped together. So even though the commission had ranked them all the same, it would be harder for the commission to rank them now differently because they're all lumped under the same offense. All age cases, that is to say, cases where age is an element of the crime, are placed in a new subdivision 1A of each statute. In addition, non-age cases, that is to say, cases where age is not an element of the crime, are divided between subdivisions 1 and 1A. 1 is reserved for adult victims and 1A is reserved for child victims. So we'll be referring to these in our discussion as age cases and non-age cases, even though after the change, it is an element of the crime that the victim be under the age of 18 to qualify as 1A, and it is an element of the crime that the victim be an adult to qualify as a subdivision 1. And those subdivision 1 and 1A distinctions are made throughout each of the 4 degrees of criminal sexual conduct, 1st degree, 2nd degree, 3rd degree, and 4th degree. This doesn't apply to criminal sexual conduct in the 5th degree. So The staff recommended response, first of all, with respect to age gap and age threshold changes, make no guidelines changes other than conforming changes. So essentially what that would do is follow the lead of the legislature, which is saying that sex against a 13-year-old should be treated more seriously than it is. So that those would, having been elevated to CrimSex 1 and 2 from CrimSex 3 and 4, the guidelines would follow suit and rank them. Rank offenses against a 13-year-old the same as offenses against a 12-year-old are currently ranked. The second recommendation is to rank prohibited occupational relationship offenses at severity level C and severity level E. That's how those offenses are currently ranked, all individually ranked. This would rank the lumped together offenses of prohibited occupational relationship offenses at those same severity levels. Because of the reorganization, there are a lot of differences in how the subdivisions are numbered. The staff recommendation is to treat the reorganized offenses in the same way that corresponding offenses with the same elements are now treated. But see next slide. So we'll be discussing that in a minute. And make conforming technical changes. So I'm going to jump ahead to the next slide. So the next slide is covering materials on a separate paper, which is numbered as 1A2 in your hand. I'm sorry, 4A2 in your handout. And that has to do with this particular issue of dividing non-age CSC offenses by adult and child victims. And again, what we mean by non-age CSC offenses are those offenses which under current law do not have an element of the age of the victim. You know, after the change, they will have an element of the age of the victim, but the other elements of the crime remain the same. It's just that they're divided between subdivision 1 and subdivision 1A. And when we brought this up in May, there was at least some commission members, or at least one commission member, expressed an interest in at least exploring the idea of punishing the newly divided offenses differently depending on the victim's status as a child. And it was pointed out in the June meeting, something I hadn't thought of, that after these non-age cases are reorganized, an aggravated departure based on the victim's status as a child will no longer be possible. And that's because under case law, and really I think the guidelines, at least commentary, suggests that this is the way it should be. You don't punish, you don't make an aggravated departure based on a fact that's already an element of the crime, because the commission presumably considered that element of the crime when they were ranking the offense. And so the presumptive punishment, the presumptive guidelines penalty should already take that element into account. So that's sort of the rationale why you can't do an aggravated departure based on an element of the crime. There is a mitigated, an aggravated departure factor that's based on the victim's particular vulnerability due to a number of circumstances, one of them being the victim's age. That's theoretical. As a practical matter, so this is kind of the other hand, there were no such departures in 2019. There were no aggravated departures for any of these age cases, these non-age cases when committed against a child, and you have all this data in your handout. There were no aggravated departures, period, much less based on the victim's status as a child. Moreover, looking at the data in 2019, there was actually a higher mitigated dispositional departure rate for child victims than for adult victims in looking at these non-age cases. So I guess that at least opens the question to the commission as to whether it's necessary to punish the child offenses more seriously than the corresponding adult offenses. So at the commission's request, staff has drafted but is not recommending a way to treat reorganized offenses differently. So this would be different from that third bullet on the previous page, which is treat reorganized offenses in the same way. So we've drafted a proposal that would punish CSC offenses against child victims with a 15% greater duration compared to identical offenses against adult victims. And identical offenses against adult victims is referring specifically to these non-age cases that were divided between subdivision 1 and subdivision 1A. So I mean, all that I think would be very confusing if you were hearing it for the first time. Hopefully it's not too confusing since we've been talking about this in the May and June meetings. But that's the staff recommendation, and then an alternative to the staff recommendation. And I just one note about that 15% duration. We explain in the paper why we picked 15%. It's basically the maximum percent that you can go without sort of crossing over into the next higher severity level for some offenses. And I mean, you could go lower than that and it would still work. But that's why we went to 15%. So, Madam Chair, that's really all I had. I'd be happy to answer questions, but that's all I had on A2.
All right, so if you're looking at the handout, I realized it might be helpful if I refer to this, but for this issue, pages 7 and 8 has the staff recommendation, starting at the bottom of page 7, going on to the top of page 8. So the staff recommendation is there, and as Nate indicated, currently staff is not recommending the differentiation, the enhancement for offenses involving children, but we really have two decisions to make. Number one, do we want to make these changes? Do we want to make these ranking decisions that staff has recommended? And also the second decision being, do we want to consider enacting this enhancement for the cases that involve children? So discussion or motion? Commissioner Middlebrook.
Thank you, Madam Chair. I would move to.
I think you might have your laptop mic might be on.
That one. Is that?
Yeah, that sounds better.
Okay. I would move to adopt the staff's recommendations as they're set out in the bullet points and on page 7 to 8.
Okay, so we have a motion. Do we have a second?
Second, Commissioner.
Second by Commissioner Mark. And I saw Judge Larkin raise your hand. So, and then I think Commissioner Estrada also may have asked to speak. So Judge Larkin and then Commissioner Estrada.
Thank you, Madam Chair. I believe I was the commissioner who asked that we take a look at this a little more closely, because when the issue was presented to us, that is the issue being whether there is any indication that by separating crim sex offenses against children from adults, the legislature was conveying a desire to treat those offenses more seriously. And I think what we heard is the group that recommended that reorganization did not rule that out. They simply didn't consider that possibility. They didn't address it. And that's why I asked for more information regarding the issue. I think my inclination is to vote against the motion that's been made, because my inclination is to say that we should treat these offenses against kids more seriously, consistent with the reorganization. However, I'm not inclined to make that motion today because I don't think we have the information we need to have an informed discussion about that possibility or to make decisions about that possibility. I mean, we have a lot of information that's been presented to us regarding who the defendants are, how they're treated based on gender and race and geographic location. But the thing that's strikingly absent, in my view, is victim impact. And that's what's most important to me. We need to know something about victim impact. Now, and I honestly don't know whether the trauma resulting from a sexual assault against a child is worse than or different than the trauma resulting from a sexual assault against an adult victim. And I think my typical reaction is that, you know, the law tends to treat children as more vulnerable and needing more protection. So that would speak in favor of a higher sentence. But on the other hand, I don't want there to be any impression that we think criminal sexual conduct adult victims are somehow more responsible or have more of an obligation to protect themselves. So I'm not sure. I'm sort of torn on this issue. So what I would ask is that if the commission were to adopt the proposal that the offenses be ranked without a provision for enhancement as the crime applies to offenses involving children, that be a temporary ranking, and that the commission agree between now and December to get more information on this issue, specifically information regarding victim impact as between child victim and adult victim, and agree to revisit this issue as we get towards the end of the year, so we can have a more informed discussion. And that if someone feels enhancement is appropriate, and I'm leaning in that direction, that motion could be made and considered at that time on a more informed basis. Part of the reason for this suggestion is, as I understand it, the commission has been directed to study the impact of sex trafficking. So it looks like we're going to be looking at some issues that might overlap with what I'm looking for, which is victim impact. So I would think we would want to know about victim impact, adults and children in the context of looking at sex trafficking. But why not get that information this fall and have the information before we decide that child victims should not be treated differently than adult victims in criminal sexual conduct cases?
Director Wrights?
Thank you, Madam Chair. Just a logistical comment to Judge Larkin's, Commissioner Larkin's remarks. So by saying, look at this in the fall and a reference to December, I assume that that is with an eye toward putting this in the January 2022 report to the legislature. So to back that up, that would mean a public hearing in December. To back that up further, that would mean a motion to propose in November. And then to back that up further, that would mean under the commission's first reading rule, that would mean the first motion, that would mean it would have to be brought up no later than October. Our next meeting is in September. So that is a very short timeline to take action. I'm not saying it's not doable, but I know the commission has other things that it's also been looking at to include resolution of the custody status point or half point issue that would also be under that constrained timeline. Again, part of the constraint here is through no fault of the commission's. It's because the legislature was a little late jumping off the starting block here. So we're a month behind, but that is a practical consideration, Madam Chair.
I just want to actually, before I come back to you, Judge Larkin, I don't think we're actually constrained in that same way, because I would consider today to be the first reading rule of the enhancement. So we would have met the first reading rule, and what we would be up against would be if we decide that there's information that we want to see or hear or discuss so that we're better informed about this. It's just a matter of making sure we schedule that into the next meeting so that we and figure out what information that is that we were looking for, and then put some time on upcoming agendas for that. So I don't know. Do you disagree with that?
No, Madam Chair. I can't remember what the rules say. It has to be discussed, and I'm sure it would be discussed to a sufficient degree at a previous meeting. So,
Yeah,
that's fine.
I think so. Okay. Commissioner Larkin, did you want to respond to that?
Yeah, and I would just say, as someone who's serving on the custody status work group, I mean, I think we're making good progress there. We'll talk about that later. So I don't know that that issue is a reason not to address this important issue. I think we can handle both of them. And I mean, in terms of what information I'd like to see, obviously victim impact issue information, what's the impact on kids, what's the impact on adults. I'd be curious to know, and I think this is something the staff could find for us, is what's the breakdown of cases where there are child victims versus adult victims, and then for kids, under 14, above 14. So we get some sense regarding who these offenses are being committed against. And then also recidivism rates. Do we have higher recidivism rates for child victims? My gut, as a judge and a public defender for 13 years, tells me we probably do. So if this is a crime where children are targeted, and if it's a crime where offenders reoffend against children at a higher rate than against adults, I think that would be relevant to our discussion. I just think there's a lot of information we don't have before voting on this important issue.
Chair Mitchell?
Okay. Yes, Commissioner Estrada, I was just about to, is that who said?
Oh, I'm so sorry. No, this is Commissioner Honnold. I don't have my video on, so I can't put my hand up.
Oh, no, I'm glad you spoke up. I think if you would hold on for just one sec, I think Commissioner Estrada was in there ahead and just hasn't had a chance to say her thing, and then we'll come to you, Commissioner Honnold.
I was only going to second the motion.
Oh, okay. Okay, thank you for clarifying that. Okay, Commissioner Honnold.
I was just going to say that I think for me on this issue, the most important thing would be recidivism rate, because I think it's very difficult to measure the impact on child versus adult victims just due to a lot of different factors. I mean, even if you look at, say, the lifetime financial impact for a victim, that likely would always be higher for a child because they were younger at the time, whereas adult victims can be from 18 all the way up into, they might be seniors. And so I think that it might be difficult to try and measure, the impact between those two groups, as well as just the fact that there is a lot of overlap. People who are victimized as children tend to be victimized as adults as well. And so, on that aspect, I probably, any kind of research probably wouldn't change my mind on the impact overall, because I know that there's so much overlap. And so many of those adult victims have been child victims, and so many of those child victims may end up being adult victims as well. And so for me, I think the most important thing would be recidivism.
Is that Commissioner Mark? And who's raising their hand? Oh, no, I'm sorry. You're right here in the room. It's Commissioner Ladd.
Thank you, Madam Chair. So I would echo Judge Larkin's comments. I guess a couple of questions that I just have maybe are more procedural. Is there such a thing as sort of setting something temporarily with some prescribed process to come back to it, or does it just by default become that unless we revisit again? That's my first question. And then my second question would be, is if we need this information, and I think Judge Larkin did a good job of saying there's a lot to unpack there in terms of analyzing it. In the timeline that we have, what kind of data are realistically could we get that would put us in a better position down the road than we are now? I guess that's my question.
Yeah, so I think procedurally, we would be making the rankings, and it would be up to this commission to identify that we have sufficient interest to continue to revisit this issue. I haven't put my 2 cents on the table, but I'm also very conflicted about this, and I would be very open to continuing to talk about this in the future. So I'm hearing a couple of people who are interested in that. So I think we could, if we pass these rankings today, then we would just continue to have this on the agenda and bring forward the information that we could bring forward in the time that we have. I do think recidivism is going to be tricky and challenging, and I'm not sure what options might be there.
Madam Chair, I've been raising my hand, but apparently I'm not on the
I'm
screen.
sorry.
So, no, I understand that you can't see me. I just wanted to support Judge Larkin, and I think I mentioned several meetings ago that there was a Canadian study that was done over a 10-year period involving victim impact on children that I think is relevant to this discussion. And I think that's very important. And I think doing this study would be very important. At this point, I'm not sure procedurally how we address it, but at this, I would say that the I can support the majority of the motion, but as it relates to this, the children impact, I don't support the motion.
I think I just want to clarify too that even if, I think there's two things going on. We have to set the rankings. And then if we are to treat the offenses that involve children differently, that would be a separate guideline that creates an enhanced penalty for those cases. So regardless of whether we enact that piece or not, these are the proposed rankings for these offenses. So I don't think there's an issue. I don't think anyone here is disagreeing about those potential rankings. We're just trying to figure out, do we also want to deal with this potential enhancement at the same time, or do we want to delay deciding whether or not to enact the enhancement until later this year? I saw Judge Larkin raise her hand.
Thank you. That's helpful to clarify it that way. I would add though for Commissioner Ladd, it's my understanding that the commission did something similar to this before I was a member with regard to child pornography sentences. In other words, came to some sort of preliminary agreement and then said, we'll come back and commit to taking another look at this. So I don't think this process is unfamiliar to the commission.
And then Nate, you were going to say something about recidivism.
Yes, thank you, Madam Chair. Well, first, I don't think I think it is true that there's not such a thing as a temporary ranking or provisional ranking. But obviously although the chair sets the agenda, the commission always votes on the agenda first item. And if the chair's agenda is not satisfactory to the commission can change it and address what they want to address. My inclination, I'm reluctant to make any promises about what we can do in-house with respect to recidivism, especially given the timelines that we're talking about. We could certainly try to do that. I guess my inclination would be, as a first approach, to do a literature review of social sciences literature and see if there is information out there. Justice Dietzen mentioned his awareness of at least one study, but there may be more studies that specifically deal with recidivism rates among sex offenders who commit similar offenses against adults versus children. Judge Larkin's question.
So any further discussion?
Can I just ask a point of clarification? What is the
Commissioner
motion
Ladd.
then that's actually on the floor?
Right. Do you want to address that, Commissioner Middlebrook?
Sure. The motion that's on the floor is the staff recommended response that's on, the bullet points are on page 3, and then they're set out on page 7 and 8. And if I could, Madam Chair, Judge Larkin, when we ranked, I was on the commission with there was some new offenses on the child pornography that we ranked based on the legislation. And then the commission went back, studied that and relooked at those. So we had passed, or we'd approved the ranking, and then the commission looked at it later. So that was the process on that particular question that you had.
So the motion, I think, is to accept the staff recommendations. I guess maybe just to sort of, the motion is to accept the staff recommendations. There's no motion regarding the child enhancement piece right now. I think what I'm saying is, if assuming that we don't have a motion on that after we deal with this one, that, I would say we would continue to put that on the agenda and continue to consider that this fall. It's just not part of the motion. Unless somebody wants it to be. So.
Madam Chair.
Yeah. Yes.
So
Nate.
I would say from a procedural point of view, if somebody were interested in making that alternative, essentially now would be an appropriate time to make a motion to amend the Middlebrook motion to add, an exception that for CSC offenses against child victims, increase the duration 15% compared to identical offenses against adult victims. So I mean, it's really very similar to this motion. It just has that exception for those divided offenses.
Well, you're saying to go ahead and put it on.
If somebody were interested in doing that, I'm
Yeah,
not suggesting.
somebody could.
At this point, I haven't even heard anybody say they're interested in doing that, but procedurally, that's how one could deal with the alternative paper if they were interested in doing that now.
Oh,
Commissioner Larkin.
I mean, I'm happy to do that now. I think we would be wise to have a little bit more information, but, and I don't know, can we amend it that way? It certainly wouldn't be a friendly amendment. I mean, I don't know that we can combine it that way, can we? I mean, Commissioner Middlebrook, would you accept that amendment to your motion to add the 15% enhancement?
No, I wouldn't accept it. I do think we need to look at it further. I think we're all kind of in a rush here. I feel very rushed about it. I think we do need more information. And I know we need to rank these changes that came about and these new offenses that the legislature's passed. And it doesn't preclude us from looking at a sentencing enhancement so we can discuss it more. We can look at other, bring in more data, bring in studies and look at it further. But I think, so I would not accept an amendment to my motion at this time.
Madam Chair.
I think that Director Wright's unintentionally muddied the waters there. I think that it sounds to me, Commissioner Larkin, like what you're really asking is for a friendly amendment to her motion to delay consideration of the enhancement until later this fall. That we wouldn't be voting on that today, but we would take it up again further down the road.
Well, I guess,
Commissioner Larkin.
I'm just trying to keep it moving. It could be in the alternative. We could take a vote on adding the enhancement today. If it passes, we're done. Alternatively, we could vote on delaying consideration of that.
Okay, well then, I think what I'm hearing then is that we move forward with Commissioner Middlebrook's motion as it is, and then if somebody wants to make a motion on the enhancement following that vote, then we can do that. Commissioner Larkin?
And I just want to be clear, since the director has sort of put this in the context of this needs to be an amendment to the motion that's on the floor. I thought because it was presented as two separate reports that it would be two separate issues. In other words, we could vote on whether or not to adopt the recommendations as to the rankings, and then we could separately vote on whether to have the 20 or 15% enhancement. So I just want to make sure we're not foreclosing that possibility when I cast my vote on the motion that is before the commission.
That's exactly what we're doing right now. So right now, we're only voting on the rankings. And then if you or anyone else would like to bring a motion regarding the enhancement, then we can address that issue in the next motion. Does that sound good? Okay. Okay. With that, is there any more discussion before we call the roll on this, on the rankings for these offenses?
Well, Madam Chair, I appreciate we're trying to work together on this, but I can't support the motion as it's framed when it has us acting on adopting the staff recommendation on this point, which doesn't include child enhancement. So I'm not sure how you get from there to saying we're going to, but we are going to study it, and then with the possibility of changing that part of the motion that is now before us down the road. And I'm I feel like Commissioner Middlebrook, that we're being rushed, and it's unfortunate, but the way that it's procedurally framed, I think I have to oppose the motion that's pending.
I'm not sure, Commissioner Dietzen, I don't think that is what we're doing. But maybe you could point out to me how her motion includes the, making a call on the enhancement piece. I don't think it does, but maybe you could help me understand that piece.
Well, the reason I'm saying that, Madam Chair, is that third bullet point, I think, incorporates rejection of the, I'll call it the enhancement portion.
On here.
I mean, that was the point of staff recommendation.
So which one is that?
The treating reorganized offenses in the same way that corresponding offenses with the same elements are now treated.
Okay, so is that also in the language on 7 and 8?
Yes, that is,
Okay.
let's see, so that is the fourth bullet, actually, under the MSG staff recommendations in the paper at the top of page 8.
Okay, so if Commissioner Middlebrook accepted a friendly amendment to remove that bullet from her motion, and I just want to know what's in there that matters to you as staff.
Right. So without that bullet,
Yeah.
so, and if I can, here's why I brought up the amendment idea, because to me so an amendment, it doesn't have to be a friendly amendment. It could be a motion with a second to amend the Middlebrook motion. And then there could be debate on that and a vote on that, and it would either fail or succeed. And that amendment would be to essentially amend the third bullet to say, except that offenses, against children would be treated 15% greater duration than.
Okay, I'm trying to get to
Right.
how do we not deal with that issue on this vote?
Okay.
That's what I'm trying to get to.
Right. I think we can just, we kind of have to do this vote, because if we don't adopt the third bullet, the 1A offenses will be unranked. Frankly, every offense that doesn't was jiggled around will be unranked, because the commission, all the subdivisions are wrong under the current guidelines. So if we don't adopt the third bullet, we'll have a bunch of unranked offenses come September 15th. So we have to adopt the third bullet at this time, and we could either take it as amendment to the third bullet or a new motion after this is done to say what we'd like to punish crimes against children more severely than identical crimes against adults.
Is there any way to amend that language so that it's not addressing the enhancement? That's what I'm trying to figure out.
So the way we wrote up the enhancement provision is it uses the same rankings, either the staff recommendation or the alternative to the staff recommendation. They all rank everything identically. It's just that under the alternative, there's an asterisk on A, B, C, and E to say, oh, but if this is one of these offenses, then there's a 15% durational bump. So I don't see this in my head. I don't see this being inconsistent with the second motion. It's almost like the foundation upon which the second motion is built.
Commissioner Middlebrook.
Thank you, Madam Chair. I guess
I'm sorry.
part of the reason that I'm making the motion as the recommendation is because I think they do need to be ranked, and they need to be ranked so that they can go to the public hearing and be decided in the September meeting. I certainly understand the enhancement, but I also have some concerns about that, which is why I'm not willing to amend my motion. I think we do need to discuss it more. I think that it's very difficult to say that this 15% should be categorically applied whenever there's a child victim. Most of these cases are really fact-specific, offense-specific, kind of, there's a lot involved. And I don't know that I can say that an adult victim impact is not, is less than a child victim impact. I think that Commissioner Larkin, you're right, we need to look at that. I also think that categorically, there are so many different cases, and this enhancement is going to be applied to every case. And yet, on some of the cases where there's the age differential or the age designation, like the ones under 14, are those cases really less serious than the other ones that we're talking about doing the enhancement on? And I think that, there's other options, and I think we just need to look at it more. And that's why I don't feel that I'm willing to amend my motion until we can study this more. And certainly we won't be precluded from doing that by ranking these 1As today under the proposed recommendation by the staff.
Commissioner Larkin?
Thank you. I don't see how we can vote on both issues at once, because the problem's going to be, okay, I'll move that we adopt the 15% enhancement. And now you've got a situation where people who want to support the rankings but don't support the enhancement are going to be voting against the rankings. I just don't see how this works. I think they have to be separated. I mean, because you're going to have people casting a vote based on one part and not the other. Right?
Right, that's what I'm trying to puzzle through is there a way to do this to maintain that separation between the two issues so that we are voting on the rankings first, just the base rankings, and then voting on the enhancement second. And I hear Commissioner Dietzen is concerned with this third bullet because he believes that precludes the enhancement vote from occurring, and I don't think it does. I think what staff has explained to us is that would rank those 1A offenses the same as the similar crimes are ranked today.
Madam Chair?
Commissioner, was that Commissioner Estrada?
Yep.
Yes.
I think Commissioner Middlebrook described how this process happened before. And if I remember correctly, what we did was exactly adopt what staff recommendation was, but the friendly amendment included language that said, and we will further investigate this in the fall for possible re-ranking for that January. Is that something that we can do here? Because I do agree that we do need to rank them. And I also agree with Judge Larkin, who recognizes we're going to be torn. If we have two opposing proposals here, we're going to be torn. But what I heard pretty much everybody say is that they're willing to continue to investigate and learn more and gather more information. So I'm wondering if a friendly amendment can be made to the current proposal that says, yes, we will adopt what staff is recommending, and we will continue to gather information to come up with possible re-ranking in the fall or the end of December. I forgot what the timeline was.
I think it would be we rank them according to staff recommendations, and we will continue to investigate the potential for an enhancement in the fall. That would be the change if we had it. So yeah, I think that's a potential if Commissioner Middlebrook wants to consider that. The only other thing that I can think of is if we looked at that third bullet, and Nate, you tell me if this blows things up, we could potentially change that language to say rank reorganized offenses in the same way that corresponding offenses with identical elements are ranked in the existing guidelines. I don't know if that would solve it for you, Commissioner Dietzen. Commissioner Larkin?
I'm not sure, Madam Chair, if that does, because the way I see it is we either have to go all in and go with the change, which is what Judge Larkin was proposing, or go with Judge Middlebrook. If we went with Judge Middlebrook's motion, seems to me we'd have to add a sentence that says, but the commission is concerned that child, there should, that there is we have not had the opportunity to investigate the impact on these sex offenses on children, and that we're going to do that. And it may well be that we change or add that enhancement, and that becomes part of the language of the motion that gets adopted. If we have something like that in there, I think I'd be fine with that, because we are adopting it, but we are saying that we are going to investigate it with the possibility of adding the enhancements. The enhancement singular, I guess.
Judge Mark and then Judge Larkin.
I was just going to suggest some language in that third bullet, subject to possible revision or subject to further to revision after further study, treat reorganized offenses, so that we leave that open, but at least we get this accomplished now.
Subject to revision after further study.
Thing like that.
Subject to further review. Commissioner Larkin?
And again, I just need clarification in terms of procedure. This is an action item, and the staff, although it doesn't recommend the 15% enhancement, put that out there for the commission's consideration today. So am I correct that that is on the table? In other words, that is something we can vote on today?
Yes.
Well, then, you know, maybe if we can't get agreement on the amendment, we should just vote on Commissioner Middlebrook's motion, and then I will separately move, as long as it's on the agenda, to adopt the 15% increase.
Yeah, I mean, I think that's what I was hoping we would head towards. My
Okay.
concern is if people vote against this because they're concerned that it's going to preclude that second motion from coming, then we don't have a ranking, and what do we do? So that I'm a little concerned about how that's going to all fall out. Commissioner Larkin? Yeah.
And that's not my intent. I mean, I think it should be, we vote on these rankings and then we separately vote, should there be a 15% increase? And I can speak in favor of that today for this reason. We've been told, well, first of all, the 15% enhancement would be to the range. And we've been told that because of how the legislature has re-ranked these, we're not going to be able to have upward departures based on particular vulnerability of the victim based on age, because age is now an element of the offense. So we're losing the ability to treat these offenses more seriously in those particular cases where there are substantial and compelling circumstances justifying a departure. On the other hand, we're also being told that age-based crim sexes are an area where there is a high downward departure rate. So, you know, we can raise it, keep the ability to do what would be an upward departure without compromising the ability to do a downward departure. So in that sense, it's not like a mandatory 15-month increase. It's still something that's going to be subject to sentencing discretion. It just allows a bigger range in cases where it's appropriate.
Commissioner Middlebrook?
Oh, thank you, Madam Chair. I just wanted to make a couple points from Judge Larkin. I actually disagree that this that with this new reorganization where you have the child victim. I mean, age has never been an aggravating factor that could be used for the past 20 years since the State versus Taylor case. Age you haven't been able to use age as a aggravating factor, but the court in several cases looks at, actually they do look at the age of the child with regard to victim vulnerability, because there's a big difference between, an infant toddler situation. And if you look at even the most recent case of Barthman and another one is Court of Appeals decision in Muhammad, they did look at victim vulnerability even under the age, where the age was an element. So I guess I tend to disagree. And I also think that the 15% sentencing enhancement is also going to preclude, and certainly as a defense attorney, I would be arguing that no other departure is allowed if you're going to have that based on the child's age. So I think that it's going to preclude prosecutors and judges from asking for a higher departure when there are certain circumstances like the Muhammad case, or even in Barthman, where there are factors that would be aggravating that do relate to age, but they're not specifically age. So, I guess in that sense, I think that reason isn't sufficient to have this. I also don't know that, the certain ones that you're going to put the enhancement would apply to, how are those more serious than the other? Try to push through a 15% where we're also
I'm losing sound for Judge.
I am too. Yeah. I was just going to ask, is it just me, but I didn't hear
don't
half
have
of what Commissioner Middlebrook just
information
said.
that
Couldn't understand who was talking or what they were saying.
It sounds like we may be having some
Madam Chair?
connection issues.
Commissioner Larkin?
But I mean, I can hear the chair. I heard Justice Dietzen, but Commissioner Middlebrook is garbled. So I don't think it's on my end.
Okay. Okay, I think in the future, just pull the mic closer to your desk. Okay, Commissioner Ladd has the floor right now.
Are you able to hear me, Judge Larkin?
Yes, perfectly.
Okay. Going back to the suggestion by Judge Mark related to that third bullet point issue, if we add the language at the end that simply said, subject to further review of potential enhancement for child victims, that would allow us to move forward on the issue that we have to rank these offenses. But it also, I think, makes very clear in the intention, maybe not agreed upon what the enhancement is or isn't, that we need further review and that we do want more information. But it's memorialized somewhere, and I would feel comfortable with that kind of language. I appreciate Commissioner Middlebrook's comments related to all of these things, but I do think that we do have some marching orders, if you will, from the legislature to look at this and to address these child victims differently. And so I'm not prepared to do that without more information, but I think if we do that with that subject to language in there, that allows all of us to come forward and maybe propose lots of alternatives for us to consider, but it memorializes it so it makes clear that we're not done and finished with it.
So procedurally, are you asking for a friendly amendment, or are you wanting to move to amend her motion in that way?
Well, I guess I would ask Commissioner Middlebrook if she would accept that as a friendly amendment to her motion, to address that third bullet point language as I've indicated.
Can you hear me now? Can you hear me? Those of you on the WebEx, can you hear me?
Yes.
Okay. Yeah, I would accept
Yeah.
that friendly amendment.
Okay, and then who was
I
the
would as
second?
well.
or-
Second.
Mark, but could we just clarify what the language of the friendly amendment is?
Yeah, can you say it again, Commissioner Ladd?
So so the third bullet would essentially remain as it's stated, with the addition toward the end that says that subject to further review of potential enhancement for child victims.
Okay. Does that make that clear, Director Wrights?
It does, if that's acceptable to the
And
maker in a
then,
second.
yeah, Commissioner Middlebrook.
Yeah, I would accept that amendment.
And then Commissioner Mark, you were the second on this amendment. Do you also accept that friendly amendment?
Yep.
I don't hear you, Commissioner Mark. Are you there?
Yes, I accept it.
Okay. So the motion has been amended to accept, it's basically to accept the staff recommendations on pages 7 and 8 of the materials, except that the third bullet is changed to say subject to, let me read the language again.
So it's the third bullet on the slides. It's
Oh,
actually the fourth
thanks.
bullet in the paper. but-
Got it.
So it's subject to further review for potential enhancement for child victims.
Okay. Any further discussion, given the revision to that motion? Thank you for leading us through that, Commissioner Ladd and Commissioner Mark. You both provided that option. Since hearing no further discussion, I'll ask Director Wrights to read the roll on that motion.
To the Middlebrook motion as amended to adopt the staff recommendations in section A2, subject to further review for potential enhancement for child victims. Estrada?
Yes.
Estrada, yes. Blakey? Blakey absent. Dietzen?
Yes.
Dietzen, yes. Honold?
Yes.
Honold, yes. Hansi? Hansi absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Any further motions at this time? Okay. If it's okay with everyone, I'd like to take a 5-minute break and then we can come back and continue on with the list, other things call. So what time is it now? Go ahead.
It's, looks like it's 2:27. I was just going to say, so we are in the west wing of the Capitol.
So it's a weird time. Let's come back at 2:35. Thank you.
Commissioner Estrada,
Yes.
I just want to make sure I can hear you because Nate was garbled as well. So I think it's something with that room perhaps?
Yeah, I
you.
think that they have to speak in their mics a little closer.
Okay, all right. Is Commissioner Middlebrook there as well?
Yes,
All right. Thank you.
no problem.
I think we did have a slight problem with connection from the host for a few minutes, so that may have also caused the problem. This is Jill.
Yeah, you were sounding garbled to us as well, Judge Larkin. So I think it was an internet
Okay.
connection issue here at the Capitol.
I don't doubt that as someone who works over there.
Okay, I'm going to call the meeting of the Sentencing Guidelines Commission back to order. Hopefully everyone has returned to their screens or desk. We're all here in the room. Is it possible for you to move that little box up though, so I can see the other people too?
I'm sorry, I didn't hear you.
Can you move the little box? Like I can only see.
Yeah, it will block, so I'm gonna move this over just a little bit.
Okay. Okay. Yeah, that's great. Thank you. All right, so we're going to continue on with the agenda. The third item here is considering rankings for the new offense of criminal sexual conduct in the 5th degree. I'm going to hand it over to Nate for that.
Thank you, Madam Chair. So under current law, criminal sexual conduct in the 5th degree is, I guess, sort of the base offense, as I think of it, is non-consensual sexual contact. So that could be, over under clothing, somebody, groping somebody, that sort of thing, where there's not necessarily force or coercion or other elements that might make it a criminal sexual conduct in the 4th degree or criminal sexual conduct in the 2nd degree. And that's sort of been the catch-all criminal sexual conduct offense in the past. But it's only been sexual contact, not sexual penetration. There is a felony criminal sexual conduct in the 5th degree for repeat offenses. But what this new felony is criminal sexual conduct in the 5th degree for non-consensual sexual penetration. And that is a felony even for the first offense. It doesn't require a repeat offense to be a felony. For the first offense, though, it only has a 2-year statutory maximum penalty, which is very low for a felony, which creates some ranking problems. So we really have 2 recommendations here for you to consider. Essentially, you have to make your choice. So we're asking you not to adopt the staff recommendation because we don't have just one recommendation. We have alternative recommendations. So one recommendation is to rank it at a new severity level I, which we're suggesting could be shaded through criminal history score 4. And that would max out at 24 months. And that's in your materials. If you look at Appendix 2 of the handout 4A1, which is on page 50 through 52 of your materials, you'll see what that looks like. We have a marked up version of it, and then we have on page 52, we actually have what it would look like with this new criminal history score. This new severity level I on the sex offender grid. So that would add a new severity level just for this offense. That would max out at 24 months. And the reason being that is the statutory maximum for this offense, which is sort of in the tradition of the sex offender grid to a number of these offenses. The guidelines maximum and the statutory maximum are the same. And we're suggesting that this be worth a half a point in criminal history score. So this is an issue that Jill picked up on last week, and that's why we sent out some additional materials to you that we need to think. We needed to think a little bit more about what this would be worth in criminal history. So when we're talking about the half point in criminal history score, we're talking about not for this offense when it's committed, but for a future offense. And then in looking at somebody's criminal history, you see, oh, this person had a crim sex 5 non-consensual penetration. So what should that be worth in criminal history? The reason that staff is recommending a half a point for severity level I is because, again, all our recommendations are generally to be consistent with sort of the existing structure of the sentencing guidelines as much as possible. And in this case, the existing structure of the sentencing guidelines is that the amount that a felony contributes to criminal history is dependent on the severity level. And if this is going to be ranked at a severity level I, and severity level I is less serious than severity level H, which is sort of a guidelines principle that as you go down the grid, the commission considers each offense to be less serious than the offenses above it. So if this is a less serious offense, it should get a weight in criminal history no more severe than the more severe offenses. And since H is a more severe offense, and it gets a half a point in criminal history or a full point if it's a severity level H right now, it pertains to failure to register as a predatory offender. And that's actually a little odd. It either gets a half a point if it's a first offense or a full point if it's a second offense in criminal history. So what we suggest is that you rank it at, if you rank it at an I, then you only assign a half point in criminal history to be consistent with how the guidelines work, which is that less severe offenses do not contribute more than more severe offenses in criminal history. An alternative would be to rank it at severity level H, which is an existing ranking. Right now, only one offense or two offenses, depending on how you think of it, is ranked at severity level H. That offense is failure to register as a predatory offender and repeat failure to register as a predatory offender, which is an offense with the same statutory maximum, but it has a higher mandatory minimum. So, so you could rank it at severity level H. That would create the need to shade some of those cells in severity level H, because right now, none of those cells are shaded because the one offense that it applies to has a mandatory minimum penalty of at least 1 year and a day in prison. So because of that mandatory minimum, it doesn't make sense to shade it. But if we had this offense, it would make sense to shade it. So we'd be recommending that it be shaded. And we're suggesting through criminal history score of 4. So we don't think that would do anything to the presumptive sentences for failure to register as a predatory offender. Those would still be presumptive commits under the electronic worksheet system. They should still show up as presumptive commits. They are presumptive commits by operation of law because the mandatory minimum exists for those offenses. So if it is ranked at severity level H, then the commission has a little more flexibility as far as assigning it how many points it's worth in criminal history. And we are suggesting that if a person commits a subsequent sex offense, that it would be worth a full point in criminal history, even though it's only a severity level, I'm sorry, a severity level H offense without a very high statutory maximum. We thought the commission might be concerned about the type of offender who would be committing a sex offense having previously been convicted of this type of sex offense, this criminal sexual conduct in the 5th degree non-consensual sexual penetration. So those are our two alternative rankings. And by the way, what the grid would look like at severity level H is shown in Appendix 3, which is on pages 53 through 55, with sort of the clean version shown on page 55. So those are the two alternative rankings. The other suggestions that we're making are adding this offense to the consecutive sentence list and making conforming technical changes.
Commissioner Larkin, and then Commissioner Middlebrook.
It would really help me. Could you display the options on the proposed grid for us from the appendix so we could see how it looks on the grid? The two alternatives. And I wonder, does staff prefer one to the other? If so, why?
Well, I think staff might not be on the same page with that. I was a proponent of H. Everybody else liked I. I think they liked I because, I mean, because it matches the statutory maximum. Okay, so I gotta, just a minute, please. I can't multitask. All right, so I'm gonna share my screen. Okay, so this is what, this is just the bottom part of the grid. This is what it would look like to add a severity level I. Can you see that, Judge Larkin?
Yes, thank you.
Okay, so so this is, again, maxing out at 24 months. I think the other members of the staff like the fact that this maxed out at 24 months. And now I'm showing you the second alternative where it maxes out, where it would rank at the 36 months. So if you look at severity level H, you see 24 months doesn't even show up in the white, right? I mean, you have 24 months on there, but it stops at criminal history score 4. So for criminal history score 5 or criminal history score 6, which is where you'd be getting in the presumptive commit category, it would just show presumptive sentence of 24 months, range 24 months to 24 months. That would be the only guidelines recommendation. There would be no range for this non-consensual penetration offense if they had a criminal history score of 5 or 6. So I liked this option because it seemed more consistent with what the guidelines do. There are plenty of offenses in the guidelines where the statutory maximum constrains the permissible sentence. In fact, Appendix 3 is nothing but offenses where the statutory maximum constrains the permissible sentence. So there certainly is a precedent for offenses where the grid time is bigger than the stat max time. The other thing
I think Commissioner Larkin has a follow-up question there, though. Go ahead, Commissioner Larkin.
And maybe you could address this as well. I like what you're proposing in terms of the criminal history point assignment. That is, if it's going towards a new sex offense, it's 1. If it's not a sex offense, half. Why does that recommendation apply to only one of the alternatives and not both?
Thank you, Judge Larkin. And again, we also had a very robust discussion about this among our staff as well. And I maintained that, and reasonable minds may disagree on this, but I maintained that it was not consistent with, there are basically 2 guidelines principles that are currently in effect that you'd be violating one or the other to assign a criminal history score, to assign a full point in criminal history to a severity level I offense if you were to create a criminal history score of I. And those 2 principles are, number 1, that least less severe offenses are ranked less severely. So if the commission adopts this grid, which is ranking Crim Sex 5 non-consensual penetration at severity level I, the commission is saying, according to its definitions, that this offense is less severe than failure to register as a predatory offender. And if that's what the commission is saying, that this offense is less severe than failure to register as a predatory offender, that's principle number 1. Then principle number 2 is that less severe offenses are worth less, or are not worth more, I should say, than more severe offenses in criminal history. And that principle would be violated if you have a failure to register as a predatory offender offense that's worth a half a point, and you had a less severe offense, a Crim Sex 5, that's worth a full point. That would be violated if that were ranked at H. If that were ranked at I. If you ranked it at H, though, you could get away with it because some severity level H offenses do get a full point in criminal history.
One more.
Is it another follow-up question? Go ahead.
It is, and I think this will be helpful for everyone because I'm struggling to understand the offense they're trying to capture with non-consensual penetration. I thought first this was a response to Court of Appeals case about voluntary intoxication of the victim, but I see that they dealt with that elsewhere. Could you give us an example, Nate, of what would constitute this crime? Based on what you know of legislative history, I don't know if you can answer the question, but I'm having a hard time figuring out what this crime looks like and why it doesn't fall into all the other categories. Or perhaps if anybody knows the answer.
No, I don't. Madam Chair, I wasn't on the committee. I'll tell you, it's a bit of a struggle for me. Maybe Commissioner Middlebrook has the answer, but I will say I've always thought of Crim Sex 5 as sort of, groping somebody, and where there's no force or coercion involved, but it wasn't consensual. If there's actual penetration, it's harder to see it being committed without force or coercion or intoxication, some kind of mental impairment or incapacity. But yeah, so I mean, I guess what you would have is somebody sexually penetrating somebody else without force or coercion, but where there was no overt agreement to the sex act before it occurred. I think that's probably what's being captured here. Alternatively, it would be something to plea bargain down a case to, say a crim sex 3 or a crim sex 1. If you're having problems with victim cooperation or something like that, you could use this as a plea bargain position, but that's.
Let's have Commissioner Middlebrook. You were going to speak anyway, so why don't you, maybe if you can take that question as well, that'd be helpful.
Okay, thank you, Madam Chair. It's my understanding that this came into play because the only other option where it didn't fit into a criminal sexual conduct 1st degree or 3rd degree was the gross misdemeanor of sexual contact. There was no non-consensual sexual penetration offense. And I think you're right, Judge Larkin, with the Khalil case, that there was the question on that there was no force or coercion. So the only option would have been if it wasn't mentally incapacitated or the voluntary intoxication didn't apply, then this crime would just be a non-consensual sexual penetration case. And that's my understanding. So where it doesn't fit into one of those subparagraphs in the criminal sexual conduct 3rd degree. And then, Madam Chair, I have a question for Mr. Wrights.
Go ahead.
I guess my question is with regard to the H level, if this was put into the H level, just to clarify, are you saying that it could not be a half point on any criminal history going forward? If it's put into H, that we couldn't decide it would be a half point?
Madam Chair, no, that is a half point would be consistent with H and it would be consistent with I. I'm just saying we recommended a full point for a sex offender because, just again, this is obviously commission's choice. We're just putting something out there as a recommendation. You can think differently on it. But we were thinking if somebody had committed this offense previously and then were convicted of a new sex offense, it would seem to be a pretty concerning thing to have in criminal history and should be worth more than a full point is what we were thinking the commission might think. But you could take, so I'll pull up the slide again. So you could take the alternative of ranking it as severity level H and just decide that it's worth a half point in criminal history across the board. That would be fine because H is a little funny. It's got half point and a full point. You really have some options there and it would still be consistent with how it's been ranked. But I think what Jill pointed out is this is a decision the commission has to make. And it was one that eluded me. So that's why your materials have been updated.
Oh, just one moment. Commissioner Ladd, I'll get to you in just a sec. I'm actually really confused about the custody status point. Maybe I pulled up the wrong version of the document, but I'm not seeing in the actual changes to the guidelines, it looks wrong to me. I'm looking at, I am looking at pages 18 and 19, I believe. And on page 18, so this is the option of H, right? So
Are you
if we
looking at
went,
the V3?
I think so,
Okay.
for A1, B3.
V3, yep.
Okay, so on page 18 of that, it's got a full point for when we're looking at if this offense is on the standard grid or drug offender grid, it says it's a full point for failure to register and a half point for other offenses, which I think is backwards from what you said. And then down on the next page, when the current offense is on the sex offender grid, it says a half point for failure to register and 1 point for other offenses, which seems I don't think that's what you intended it to be. And so I'm really confused about what the proposal is.
Okay, so the reason it's worded that way, Madam Chair, is, so the first change there, which is to 2B1A. 2B1A is a chart that shows how an offense is to be weighted if the current offense, which from our perspective is the future offense, if the current offense is on the standard grid or the drug offender grid. Currently, it's weighted as a half point if it's a first-time failure to register as a predatory offender, and a full point if it's a second-time failure to register as a predatory offender. So what we suggest here is assigning it, and you could make it a full point for this new offense. This is just a staff recommendation. But what this recommendation is to do is to make it a half a point for the new offense and a full point for the subdivision, the 243.166 subdivision 5C, which is that subsequent failure to register. So that's status quo. The subsequent failure to register as a predatory offender is worth a full point. Then if you go on to the next one, we're flipping it, where we're saying it's a half point for 243.166 subdivision 5B, which is the first time failure to register, and it's one for other offenses, which would be subsequent failure to register and this new non-consensual sexual penetration for offenses that are on the sex offender grid. If the current, just to say the future offenses on the sex offender grid.
Okay, so then let me just make sure that I understand. Thank you. I didn't see the C and the D and the B,
Okay.
and that was where my confusion arose. So thank you for that. But let me just understand, for failure to register today, it's a half point the first time and it's a full point the second time?
Right.
Okay. So we would have to either mirror that or do something different from that. If we ranked it at H, we'd be contending with the fact that we have this first offense, second offense kind of criminal history weight at level H.
Well, so the first offense, second offense doesn't really apply to this offense because this is a first offense. If there's a subsequent offense, it's going to be dealt with under a different, it's going to have a different statutory maximum, and it's going to be dealt with under the felony provisions that currently exist for CrimSex 5, which
Okay.
I'm embarrassed to say I'm blanking on what that's ranked at. Is that ranked at a G? Or
It's all right.
CrimSex 5 currently ranked at what? A G. Okay, so CrimSex 5 is currently ranked at a G. So that would apply to this offense. If it's a subsequent offense, then it's going to be ranked at a G and it's going to get a full point in criminal history
Okay.
regardless.
Okay. All right. Thank you very much. That helps me. I'll just put it out there that right now, to me, ranking it at H with a half point feels like what I'm interested in pursuing, but everyone else can talk about what they're interested in as well. Commissioner Ladd.
Thank you, Madam Chair. I guess one of the things I'm struggling with is plunking this particular provision into H, because frankly, H is always a presumptive commit, as you indicated, by operational law. So even if it's a first-time offense, regardless of how many they're going to get, it's going to be worth half a criminal history point or one criminal history point for the conduct. It seems odd that we would categorize this level of offense with another offense that always has a commit to the Department of Corrections, even on a first-time offense. And it's not really a sex offense in the sense that it's not an act with a victim. It's really a paperwork issue and not complying with the registration requirements. I'm not minimizing that at all. It's what I hear defense attorneys argue all the time. It's a technical violation of the law, but if you get charged with that, it's a committable offense, and it seems somewhat inconsistent to me that we would put another sort of ranking in that same layer. That's not that. And I mean, I do think that the H rank is an outlier to all the other things on the grid in terms of how it operates. And so that's just an observation I make. And so I'm struggling with having this one be in with that group.
Right. And that is I think that the staff members who opposed me took exactly that position. Although The two counters to that are, one is, well, it may be an outlier, but it's still considered by the commission to be the least severe sex offense on the grid. Even though the legislature has decided it's a presumptive commit across the board, the commission has decided it's the least severe sex offense. The other is, I think somebody brought up in our internal discussions, severity level 7 on the standard grid was sort of always the DWI severity level because that's how it was created. But the commission after that has decided, you know what, there are some other offenses that could also fit at severity level 7. So even though a severity level may have been created for a particular offense, there is precedent for sort of expanding the use of that severity level to other offenses.
And just to follow up with that, I understand that. I guess what I probably said it kind of clunky and not very well. All of the offenses related to everything else on the sex offense grid has victims. The predatory offender it's a huge public safety. And that's why I think it's very serious and needs to be taken serious. But there's not a direct victim per se, because they've violated the registration requirements. And, if it's coupled with another law violation that involves a Crim Sex Act, that's a different analysis, but a standalone predatory offender offense doesn't necessarily have a direct victim. These other ones do. And that's why I'm saying, I feel like it feels a little inconsistent to stick them into the same category.
Yeah, well, I'd like to respond to that actually. Because this one I've struggled with more than I think anything on the list. It's kind of ridiculous how much I've struggled with this one. For me, something that Director Wright said a moment ago, is this crime less severe than failure to register as a predatory offender? When I think about the harm to the victim, I can't make that decision. I don't feel like it is less serious. And so part of the reason why I think it should go on H is because I think it's more equal in seriousness. But I also didn't think that the sentences that ended up in the cells on level I were adequate, especially for people with a criminal history score of 0 to 2, not really changing, which does happen on the standard grid. And there I'm okay with it, but here I wasn't okay with it. And so, having that ability to bring that sentence up just even slightly by placing it in H made more sense to me. So ultimately that's how I came down, or that's sort of where I'm landing. That doesn't mean I can't be persuaded to something else at this point, because like I said, I've really struggled with this one. But that was my rationale, or that's the thinking I've been having. But I don't think the criminal history score or the criminal history weight is right, and I'd put it at a half point rather than the full point. It is shaded. Yeah.
Yes, I can pull it up. Yep. So, well, not all the way across the board, but so it's
As soon as he's done with that, then.
I think the example. Oops, I'm on the wrong. So the staff proposal for the H is to shade it through criminal history score 4, and then 5 and 6 would be your presumptive commit. But you could also, I will say, reasonable minds could disagree. You could draw the disposition line after 3 and have it a presumptive commit at 4, 5, and 6. That'd be fine too.
I was actually also thinking about that.
Yeah,
to tell you the
that's
truth,
fine.
because both H and G involve penetration, I sort of felt like there might be an argument for bringing that disposition in line in one cell there and making that the same at both levels. But that's also, there's so many decisions to make on this one. Commissioner Middlebrook.
Thank you, Madam Chair. I have another suggestion. What about if we put this new crime into an H and move the failure to register to I, and then leave it open that way? What about doing that? So it doesn't have the one in the middle, and it's, ranked by severity, how the chair feels. What about doing something like that?
Oh, Madam,
Would your suggestion be though, like what would you be suggesting for the numbers in the cells, like this, repeating them, or what are you thinking along those lines?
I hadn't really thought about that. I just was trying to figure out if there was a better way to do that that would be clear that the predatory offender's going to be white across the entire grid versus having part of it shaded. And then kind of switching the severity level so that the 5th degree is above the failure to register.
So I'm going to have Nate respond and then Commissioner Larkin's been waiting. Go ahead.
So are you suggesting, I think you can't change the rankings for failure to register at this point because the legislature hasn't made a change in the law. And your authority right now is limited to responses to legislative changes in the law. They did create a task force to look at predatory offender, the whole crime, which I think includes sentencing, and they may come up with some recommendations for us for next year. But right now, I don't think we can make a substantive change to how predatory offender registration is punished. So perhaps you're suggesting making a new ranking between what's now G and H, essentially?
Oh, Madam Chair, no, I mean, I'm not saying we should re-rank it. I mean, other than changing the letter,
Okay.
leave the same numbers, leave the same, the half point, everything that's there, leave the same grid numbers, just switching it to an I. I mean, I don't know if that's something we can't do. It's not really re-ranking it if we're leaving everything the same, is it?
Right, and I didn't understand what you were saying. So,
Yeah.
so you're basically suggesting inserting a new row between what's now G and H that would be dedicated to criminal sexual conduct in the 5th degree, non-consensual
Just-
penetration.
Right,
And-
and then have failure to register on its own at the bottom with the same numbers, the same, everything the same, other than the letter changes.
And then what numbers would you propose to put in the new severity level then?
Well, the new 5th degree would be the H, and then the predatory offender failure to register would be an I, but all the same,
Oh, I see.
exactly the same grid. And I would just change those 2 letters.
Mhm. Yeah,
Just a suggestion.
I think
that-
you could do that. It just it wouldn't be economical in terms of space to me because it essentially would be identically severe offenses. I mean, the numbers would be the same. It's just, it would be shaded. I mean, I guess by the same token, we could have a parallel line for severity level 6 offenses for assault too, because those are always presumptive commits, even though it's shaded for the first few cells.
Commissioner Larkin.
I agree with Commissioner Middlebrook. I was sort of looking at this the same way. Just visually, I don't think failure to register should share a box with 5th degree non-consensual penetration because the latter is a victim offense, like a physical victim offense. So I think that should be ranked higher than failure to register. And I was wondering whether we shouldn't put the new crim sex 5 at G, but the suggestion that Commissioner Middlebrook has made makes sense to me, where you would just have an I would be devoted exclusively at this point to failure to register as a predatory offender. The numbers in I would be the same that they are now for failure to register as an offense. And then we would have H be the 5th degree crim sex as it's mapped out here. I do like the idea though of increasing the criminal history point for the subsequent offense, because in my view, 5th degree crim sex non-consensual penetration is worse than failure to register, because failure to register seems to be a crime, against the community at large without an identifiable victim. So I don't have any problem with the notion of making the 5th degree one criminal history point for a subsequent offense.
Okay, so I am sort of hearing that there's a desire to separate these offenses from failure to register and CSE in the 5th degree. So far, the idea that seems to be gaining some traction is to basically repeat row H, assign 5th degree CSC to that, knowing that this offense is going to time out before it gets to the end. So even a person at a criminal history score of 6 could not get a sentence higher than 24 months. I also hear Director Wrights is bristling at that idea, and I don't disagree because of the economy, the economy of the grid. We've never really had a repeated row like that. Just to clarify that a particular offense is always a presumptive commit. So, it is a little unconventional to think about it that way. I blame the legislature. They're the ones that have put us in this position by giving us a very odd statutory maximum sentence here to work with. So I think maybe if there's further discussion, if anyone has any other ideas to throw out, certainly open to hearing that, but maybe now would be the time for somebody to frame a motion to put our discussion into proper context. Is Anne raising her hand?
Yeah.
Go ahead.
If you're gonna put essentially put a row for CSC 5 above H to get around the problem of having it being considered less severe than failure to register, couldn't you use the durations that Nate has proposed at I, but tweak them so that you wouldn't go a unit a day for all the first 3 cells? You can move them up, so you can make differentiations there. You could a unit a day, 14, 16, 18, 19, and then you could still go up to 24, cut it off at 24 because that's the stat max. I mean, you could tweak the durations that Nate has suggested for I and move the presumptive line back to cell 3, criminal history score of 3 if you want. And then you could not have it violate the stat max policy. You could have it at a row on the grid where the stat max is on the grid 24 months, but you don't get there before you get out the criminal history score of 6. In other words, there's nothing written in stone about the durations that Nate put on the I row. We could change them. You could change them.
Nate,
Can I respond? Yeah, so one problem with that is if you were to have this severity level between G and H, that would, because of the low statutory maximum, according to guidelines convention, you'd cap it at 24 months. So then you'd have lower durations at a higher severity level, which is definitely odd and the first time. If I can just finish, another thing I would say is if you were to rank it at H with a 36-month maximum, we'll see these later on today, there are a number of instances where the legislature has essentially changed the law to conform to the guidelines, where the legislature's increased the statutory maximum on sex trafficking offenses and that child solicitation offense to match the grid, essentially. And they may do that with this. If you rank it at H, they may say, oh, I guess the commission wants us to put a 3-year stat max on this, and they may change the stat max. Or you could rank it at G and they may change the stat max to 5 years.
Were you going to say something else, Anne?
No, we've had this argument before, so.
Okay. Go ahead.
It's just that we intentionally created H for failure to register, so it did not. It equaled the stat max statutory mandatory minimums, and we didn't have it rows on the grid showing shaded when everything was presumptive commit. We wanted to eliminate that confusion, at least for this offense. So, and whatever. I'm just saying, if you don't like the durations that we proposed at I, and that's why you want to put it at H, you can change those durations for this offense. It doesn't have to be the durations that we're showing here.
Right. Commissioner Larkin.
I think this is getting way more complicated than it needs to be because I hear consensus that 5th degree crim sex, non-consensual penetration is worse than failure to register as a predatory offender. So it should be listed above failure to register. So why don't we just have a situation where crim sex 5th degree is H? We don't use the numbers that are shown there now. We use the numbers in the alternative proposal where it caps out like at criminal history 3, and then failure to register goes down to line I with its current numbers. Why can't we just do that? It seems like that's a simple solution. So we would have H, 5th degree crim sex, just as it's shown right here, 12, 14, 16, 18, 24, a new I, failure to register as a predatory offender with whatever numbers we have for that offense now.
Do you want to make a motion to that effect?
Unless somebody tells me there's a reason not to do it that way.
Well, Madam Chair, yeah,
Right.
I guess I would, I don't know how you'd put 30 and 36 in those far right boxes if the stat max for the only offense for that severity level is 24.
But aren't we told that there are other instances on the grids where the box to the far right is unattainable because of the stat max? How is this any different?
That's true, but that's never been true of an offense that's the only offense ranked in that row. So for example, right now with crim sex 1, it's capped out at 360 and
Okay.
then it doesn't even show an upper range because 360 is the stat max.
Is there anything that says we cannot, would you go back down where we're at H, for those last 2 boxes, just put an X in them with a note that says these boxes are blank because the stat max is 24. Done. Who says there has to be numbers above 24 on this H as it's shown in the screen? As long as we explain why there aren't numbers, it seems that that takes care of the problem.
Madam Chair, similarly,
Commissioner Estrada.
thank you. Similarly, it would be kind of like I has 12 in a day, a year in a day, 3 times in a row with the same number. I agree with Judge Larkin. Why would we not be able to put 24 on
24.
those 3 boxes?
Great suggestion.
If we did, yeah, that would be my suggestion.
And then, I mean, that's fine, but it would be very anomalous to have lower durations in a more severe box. So you'd be going, sort of working down and let's take the far right column here. It would go 60 for severity level G, 24 for severity level H, and then 36 for severity level I. I'm just saying you'd kind of get to the same place by just lumping them all in severity level H. I think that would accomplish the same effect and do less violence to sort of how the grids are structured now. But they're your sentencing guidelines, so you can do what you want with them. But it would be odd.
Yeah, I mean, I think what's really tough here is I actually think we have agreement on what we want the sentences to be for these offenses, but we just don't have agreement on how to represent it on the grid. And somewhat, that's the, it's more about the construction than about the end result that we all seem to be trying to get to.
Madam Chair, I have a motion.
Commissioner Larkin.
I move that we, and if Nate, you could leave this in place for now, we rank crim sex 5th degree at H as shown on the screen, but we put 24 and 24 in the last 2 boxes with a footnote explaining that we're doing that because the statutory max is 24 months and that we create a new I dedicated solely to failure to register as a predatory offender. And it has the same numbers that currently exist in the boxes for failure to register as a predatory offender. And I appreciate that that might be inconsistent with conventions in terms of how the grid looks, but I think it's uncomplicated and reflects what the law is. And I just think anybody who looks at the grid and sees failure to register as a predatory offender and fifth degree crim sex, non-consensual penetration in the same box is going to be offended and think, how could failure to register be as serious as fifth degree non-consensual penetration? That's a worse offense. So that's my motion.
I would
Okay.
second the motion.
Commissioner Deetson seconds. Do we have any discussion? Commissioner Ladd?
I did have a clarifying question for Judge Larkin. Maybe we don't even need to address it in the motion. I know we've discussed this, half a criminal history point versus one criminal history point for first, second, that sort of thing. Is that part of this, or is that does that need to be addressed separately?
I would like to address that separately if we can.
I think we could.
Okay.
Should we?
Can I just make a comment?
Yeah.
So I guess my way of thinking on that question would be that the sort of implied criminal history ought to be 1 point and 1 point, because again, going back to the principle that more severe offenses that because severity level, what's now H.
Okay.
Okay.
Before you go there, you are getting into a new topic.
Yep.
So I would like to, let's divide the question. Let's deal with the ranking first, and then we will deal with the criminal history, the weight for criminal history, and then I think your comment would be very relevant at that point. Okay, any other discussion on the ranking? Okay, hearing none, if you would please take the roll, Nate.
Okay, to the Larkin motion to rank criminal sexual conduct in the fifth degree at severity level H as shown in Appendix 3, but to indicate only durations of 24 months in the last two boxes, with a footnote explaining that durations are constrained by the statutory maximum, and to create a new severity level I identical to the existing severity level H for failure to register as a predatory offender. Estrada?
Yes.
Estrada, yes. Blakey? Blakey absent. Deetson?
Yes.
Deetson, yes. Honnold?
Yes.
Honnold, yes. Hansi? Hansi absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, that motion is passed unanimously. If we can move on then to what the appropriate weight for criminal history should be. So Nate, why don't you go ahead and put your idea out there that you were just saying so that we have it on the table.
Okay, so I guess my initial reaction would be that, so I'm displaying on the screen here the 2B1A, which is the chart that shows the weight assigned to an offense depending on how it's ranked on the standard, if the current offense is on the standard grid or the drug offender grid. And you can see on this that as an offense goes down in severity, the weight goes down. And that's a rule that's pretty much across the board. Same thing if you look at the current offense on the sex offender grid. So and again, H is anomalous. We're talking about H, this is going to be the future I. H is anomalous in that it has a half point for subsequent offenses and I'm sorry, a half point for first offenses, failure to register, and a full point for subsequent offenses. So if weights go down in severity, then to assign a weight of 1/2 would be a little odd, because then it would go back up for a lesser severity offense of subsequent failure to register, right? Because it's a half a point at H, and then it go up to a full point for some severity level I offenses. Severity level I being the new failure to register as a predatory offender. So it would seem like the normal way to rank it would be a full point for both standard grid offenses and drug offender grid offenses, as well as a full point for sex offender grid offenses.
Commissioner Middlebrook.
Thank you, Madam Chair. I guess I would, in looking at, pages 18 and 19 that we were looking at, and that if we are doing that, why couldn't we leave it at H and I being the same custody stat, or being the same criminal history as it is already? So it's a half point for the first and 1 for the subsequent. So then you wouldn't be changing it. I mean, you could use these same, all you'd have to do is add in I. H and I.
I mean, earlier you said that a subsequent 5th degree would actually be charged at a higher level, right? So really it would be we really are talking about the first offense.
That's true.
So in both cases, if the first offense was a half point and then the subsequent for failure to register was a point, that'd be consistent with how it's ranked today, or how it's weighted today.
Right. So you'd be saying to adopt the alternative language, but just to include reference to I wherever reference to H is made in section 2B1.
Yeah. But I feel like Commissioner Larkin may have wanted to consider a full point. I feel like she may have said that earlier. Am I right about that?
I need clarification about what we're talking about. First, am I understanding, Director Wrights, that the second offense for non-consensual sexual penetration becomes a different offense under the charging statute? Am I misunderstanding that?
No, that is correct. Let me just pull up the language here, just so I don't make any mistakes, but
Okay.
I believe that is correct. So.
Okay, so what does it say here?
So, yeah, so the subdivision 1, the base offense is non-consensual sexual penetration. And then under subdivision 3, which is the penalty subdivision, it says the sentence for the base offense is subdivision 1 is a 2-year statutory maximum. But then it says it's a 7-year statutory maximum if the person violates subdivision 1 or 1A within 10 years of all these previous convictions. So yes, it is more serious.
Okay, so then that subsequent offense, we're going to need to rank that higher on the grid. Yes?
That one's already on the grid.
Okay, all right, so we're covered there. So I think that the disconnect here is the proposal for 1/2 versus 1 point is based on what type of offense the current sentencing offense is. In other words, if you have a prior crim sex 5 non-consensual penetration and you're being sentenced on a felony theft, you only get a 1/2 point for it. But if you have a crim sex 5 non-consensual penetration and you're being sentenced on a sex offense, you get a full point for it. Is that what the proposal is? In other words, it's based on what the new sentencing offense is.
Yes, so as I understood what Commissioner Middlebrook was describing, it would be a full point if the subsequent offense were on the sex offender grid. And it would be a 1/2 point if the subsequent offense were on the standard grid or the drug offender grid.
I can support that.
Was that did anyone make a motion? Or are we still just talking? I'm so sorry.
Well, let me ask this. I think we voted on what the grid looks like, and now we're moving to the point. So I will move that with regard to criminal history point assignment for the new offense of 5th degree criminal sexual conduct, non-consensual penetration, that we weight it as follows. The weight will be determined by the new sentencing offense. If it's an offense on the sex offender grid, we weight it at 1 point. If it's an offense that's not on the sex offender grid, we weight it at a 0.5 point. Commissioner Middlebrook, is that what you had intended?
Commissioner Middlebrook.
Yeah, I think so. I was basically following the same language as was on page 18 and 19, and it's that what that one does have for the first offense,
Yes, so I think
a
it,
0.5 point on both, on all grids, but a subsequent then is 1.
But I don't think that language works because I think that language is based on the concept of your second conviction of failure to register, you get a full point. And what we have in this case is your second conviction for non-consensual sexual penetration puts you in a whole different category of crime. So I think we can't just use that language because that's a different scenario. That I think what that language is saying is your first one's a 0.5 point, your second one's a full point. What I'm proposing is your first one's a 0.5 point, your second one could be a full point or a 0.5 point, depending on what the new crime is.
no.
Madam Chair, I think that is what the language on page, so depending on which alternative recommendation you're looking at, if you're looking at page 18, which I got up on the screen here, let's see, that would do what,
Okay,
basically, if you turn this to H and I, so if you just add -I right here, this would do what I think you and Commissioner Middlebrook are both saying. Because
and I can't keep track of the language at this point. I'm just trying to make this as simple as possible for people to conceptualize. So what I'm proposing is for 5th degree crim sex, non-consensual sexual penetration, we weight it as a 0.5 point if the new offense that's being sentenced is not on the sex offender grid, and a full point if the new offense being sentenced is on the sex offender grid. However you need to word that to make it happen, that's conceptually what I'm proposing, and that's my motion.
Okay. So we do have a motion. Is anyone, will anyone second that? Do we have a second?
This is Ladd seconds.
Commissioner Ladd seconds. Any more discussion on this one? I think it's clear. Do you feel like it's clear?
yes,
You got it. Okay, great. I'd say we go ahead and vote.
to the Larkin motion to weight the new criminal sexual conduct in the 5th degree non-consensual penetration offense at 1 point if the future offense is on the standard grid or the drug offender grid, and at 1/2 point if the new offense is on the standard grid or the drug offender grid, and at 1 point if the new offense is on the sex offender grid. Estrada?
Yes.
I'm sorry, I didn't hear your response.
Yes.
Estrada, yes. Blakey? Blakey absent. Dietzen?
Yes.
Dietzen, yes. Honold?
Yes.
Honold, yes. Hansi? Hansi absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes,
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion passes unanimously. And I hate to make Nate have to run through that list again for us, but I'm realizing that since we didn't go with the staff recommendations, the one piece that we haven't addressed is whether to add this offense to the permissible consecutive sentencing list. And I believe that we should address that.
And to make conforming technical changes as well.
Yes. And so I'm wondering if anyone's willing to make a motion to address that.
Judge Larkin moves to add the offense to the consecutive sentence list and to make conforming technical changes.
We have a motion. Do we have a second?
Second.
Commissioner Deaton seconds. Any discussion? Hearing none. Sorry, Nate.
That's all right. To the, let's see, I didn't write down the second, sorry. To the Larkin motion to add the new offense to the consecutive sentencing list and make conforming technical changes. Estrada?
Yes.
Estrada, yes. Blakey? Blakey absent. Dietzen?
Yes.
Dietzen, yes. Honold? Honold, wait, Honnold's not absent. Honold?
No, I'm not absent. I'm sorry. I thought I unmuted and I didn't. Yes.
Honold, yes. Hansi? Hansi absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Okay, so then the we're on to item 4. Is that it?
Already on item 4.
Okay.
No,
Item 4.
I think we've done most of the heavy lifting. Well, we still have some more bumps on the road, but sorry, that's mixing metaphors. Okay, so this is a new offense called sexual extortion. This creates, actually it's 2 new offenses. One is sexual penetration, the other is sexual contact. And these offenses are when the sex is compelled by threats to create a disadvantage or withhold a benefit. And there are a number of disadvantages and benefits that are listed in the statute. Could have to do with, threatening to disclose immigration status or withhold housing or that sort of thing. So, but the sex has to be compelled by one of these threats. It has the same respective statutory maximums as criminal sexual conduct in the 3rd degree and 4th degree. And it's clearly classified as a sex offense based on the lists that it's put on and so forth, as far as the legislature is concerned, but it's not placed on all violent crimes lists. Our recommended response is to rank these offenses at severity level C for penetration and E for contact. As an alternative, we could rank it at severity level D for penetration and F for contact, with the idea that it's not quite as coercive as criminal sexual conduct in the 3rd degree and criminal sexual conduct in the 4th degree that are ranked at those severity levels. It's more like the coercion of criminal sexual conduct in the 3rd degree and 4th degree that's in an age case where the person's consent is deemed to be legally impossible due to the victim's age. And yet another alternative is to just leave them unranked, since this is new territory, see what these cases actually end up looking like in real life, and sort of postpone the decision to rank them indefinitely, depending on how many of these cases there even are, or how severe the cases turn out to be, and let the judges rank them on a case-by-case basis. Regardless of what the commission decides to do with the ranking, we're also recommending to add to the consecutive sentence list and add to the list of exceptions to the 5-year presumptive probation cap. And the rationale being that those offenses are all sex offenses or homicide offenses, and the legislature clearly thinks of this as a sex offense.
Okay, any discussion, or does anyone wish to bring a motion? All right. Maybe I'll just start with discussion. I think when I looked at this one, my inclination was to go with the staff recommendation to rank these at severity level C and E, added to the permissible consecutive sentencing list, and also added to the list of exceptions to the length of stay. That case was compelling to me. I can't make a motion, however, so if anyone is interested in making a motion to follow staff recommendations, I would definitely entertain that. Or if someone has another idea.
This is Commissioner Mark. I'll make the motion.
Commissioner motion, to adopt the staff recommendations. Is that your motion, Commissioner Mark?
Correct.
Okay, we have a motion. Do we have a second?
Commissioner Estrada will second.
Commissioner Estrada seconds. Any discussion? Commissioner Larkin.
What's the motion? Because I'm looking at staff recommended responses with alternatives. So are you saying C and E?
Commissioner Mark, I think that's what he's saying, but I'll let
Yes,
Commissioner Mark.
I am not referring to the alternatives. I'm referring to the bullet points.
And I hate to ask this, but C on the sex offender grid, C is less serious than D, right?
It's more serious.
More
It's
serious. Okay, so
it's
you're recommending the more serious. All right, thank you.
It's a presumptive commit with no criminal history.
So that's the motion. It's for C and E, the more serious ranking.
Correct.
That is the
All
motion.
right. Thank you.
Any other discussion? That's too easy. Let's go ahead and vote.
All right, to the Mark motion to, in section A4, to adopt the first staff recommendation, including ranking the penetration offense at severity level C and the contact offense at severity level E. Estrada?
Madam Chair and Nate, I also assumed that they were including in the motion to add to the consecutive sentence list and add to the list of exceptions to the length of stay. Is that correct?
That's my understanding.
My motion. Yes, that's my.
Commissioner.
Okay, thank you. I just wanted to make sure we didn't have to vote 2 times.
Right. Okay, go ahead.
To the Mark motion as clarified, Estrada?
Yes.
Estrada, yes. Blakey? Blakey absent. Dietzen?
Yes.
Dietzen, yes. Arnold?
Sorry, I had the same issue again. Yes.
Arnold, yes. Hansi? Hansi absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Can move on to number 5.
All right, so number 5 is, I think, the simplest one we've done so far. Sex trafficking is added to the violent crimes list. The logical thing I think this is in part due to the rationale of the proponents of this change on why they thought sex trafficking was particularly harmful. They sort of emphasize the aggravated sex trafficking in particular as being a violent crime. So the staff recommendation is to only add aggravated sex trafficking to the severe violent offense list. The severe violent offense list in section 8 of the sentencing guidelines, which we'll be talking about later as well, is a list that the commission uses to enhance a penalty for repeat severe violent offenses. It increases the presumptive sentence. In addition, under the provision that allows waiver of custody status, severe violent offenses are excluded from those waivable offenses. As an alternative, you might want to consider adding all sex trafficking offenses to the severe violent offense list. That was, after all violent offenses, all sex trafficking offenses were added to the list of violent crimes. But it's also true that the commission was much more selective in the list of its severe violent offense list than the legislature was in its violent crimes list. So there's wouldn't be anything untoward about only adding aggravated sex trafficking. So in this one, this is a case where the staff is recommending only aggravated This is not an alternative recommendation. It's an alternative to the staff recommendation to add all sex trafficking offenses.
Okay, any comments?
Yeah, Madam Chair, 8, why would you not want to add all?
Nate, do you have a response to that?
Yeah, Madam Chair, Justice Dietzen, the rationale for when I considered it was that the proponent's rationale in adding it to the violent crimes list only referenced the aggravating circumstances. It didn't reference the general offense of I guess pimping in general, which is the non-aggravated offense. If it had a violent element to it, it was going to be in the aggravated sex trafficking category.
Commissioner Larkin?
Okay, so in the box on the left, what it really should say is adds aggravated sex trafficking to the list of violent crimes. That's what the legislature did. They only added aggravated sex trafficking to violent crimes list and dangerous offender statute.
Madam Chair, Judge Larkin, no, that's the box is correct. They added all sex trafficking offenses to the list of violent crimes. But the proponent's rationale only referenced the aggravating circumstances, the circumstances found in the aggravated sex trafficking offense. So that's why and also the fact that the commission's list is much more selective than the legislature's list in 609-1095. So those are my two thoughts on only adding aggravated sex trafficking to the list.
Commissioner Larkin?
What offenses would constitute aggravated sex trafficking?
Let me pull it up. So. I don't think I have it here. I think I have it in the next section. Okay, so I'm sorry, it's in the next section. It's on page 28 of your materials because that also deals with sex trafficking where the statutory maximum is increased. There has to be a prior offense. That's one. 2 is a bodily harm. So that's an alternative. Second. Third is long-term debt bondage or forced labor. I think it's at least 180 days, if I recall. And then the fourth is multiple victims. So if any of those are present, then a sex trafficking offense becomes aggravated. If those are all absent, then it wouldn't qualify as an aggravated offense.
Commissioner Larkin?
What are some examples of offenses that are on the aggravated crime of violence list within the guidelines, just for comparison purposes?
So it's found in section 8, which actually is reproduced in your materials on page 26. So we have the whole list in your materials on pages 26 and 27. So the commission, when it created the list, added labor trafficking. I recall Judge Schellhaus was adamant that that be on there, but it did not include sex trafficking. I don't know if that was an oversight, but this is certainly an easy chance to rectify it if it was. But for example, only crim sex 1 and 2 are on there. So it's a very small list compared to the lengthy list that's found in
This is what it would look like if it was added.
609-1095.
I would, if I could jump in here, I think that, so I wasn't on the commission when this severe aggravating offense enhancement was created, severe violent offense list was created. And I think what I'm struggling with is I'm not sure what the criteria is for inclusion of an offense on that list. And I would really like it if we could try to figure that out as a commission, like not today. And I'm a little hesitant to put, like we added a couple offenses earlier, but they were, similar to offenses that are already on this list, criminal sexual conduct in the first degree and second degree. But I'm hesitant to put this on now because I'm struggling with what's on what merits inclusion on this list. And 609, 0.222, this whole statute is something that we have to review anyway, that the legislature is requiring us to review this year. So I would prefer that we delay this decision and include it as part of the review and to consider whether it should go on here. And as part of that, maybe have a better discussion about which kinds of offenses, what's the criteria for being on this list. That's my 2 cents. Commissioner Larkin.
I agree. I feel like I don't have enough information, big picture information to make a decision. And I think my default position would be put everything there, but I would move that we delay a decision on the staff recommended response and study the issue as part of our directive to study the offense of sex trafficking and sentencing in general.
Okay, thank you. So we do have a motion. Do we have a second to that motion? Commissioner Middlebrook?
I'll second that.
Commissioner Middlebrook seconds. Any further discussion? All right, hearing none. Director Rice, if you would take the roll, please.
To the Larkin motion to delay decision with respect to A5 pending the outcome of the mandated review of sex trafficking offenses and sentencing, I think is in the review. Estrada?
Yes.
Estrada, yes. Blakey? Blakey, absent. Dietzen?
Yes.
Dietzen, yes. Honnold?
Yes.
Honnold, yes. Hansi? Hansi, absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Okay, so number 6 is where we actually have to rank something, right? Or or adjust.
I don't think
something.
so. So, I mean, you may end up deciding to rank it, but essentially this is a 5-year increase to the statutory maximum of each of the 3 sex trafficking offenses. So there's the first degree, the second degree, and the aggravated. We're recommending just making conforming technical changes at this time. We're not recommending any ranking changes. But this does require actually changing the numbers in the grid because right now severity level C is capped out at the 15-year statutory maximum. So the numbers don't reflect any numbers higher than 180 months, but because this is actually increasing the statutory maximum for sex trafficking second degree above 15 years, there actually will be, we need to change those numbers to give a little bit more breathing room there in severity level C. So our recommendation is to make conforming technical changes.
Okay, do we have a motion? Commissioner Middlebrook?
Thank you, Madam Chair. Yeah, I will move as Director Wrights indicated to make those technical changes.
Do we have a second?
Second.
Commissioner Dietzen seconds. Any discussion on the motion? I would just say I think this makes sense. I mean, we will certainly be reviewing this as part of our full review of this statute, but this is a sort of an interim steps to avoid confusion in the field. So I think it makes sense for that reason. Commissioner Larkin.
So what we're doing then with this motion is putting a bigger number at the end of C, so we're within the statutory max.
Right. Yep. So and 180 months will still be the top number for crim sex 3 because that's still its statutory maximum, but there'll be a little bit more room for sex trafficking second degree.
Any further discussion?
Sorry, who was the second on the motion? I just missed it.
Commissioner, yeah. All right, hearing none. If you would read the roll, please.
To the Middlebrook motion to make conforming technical changes consistent with the staff recommendations in section A6. Estrada?
Yes.
Estrada, yes. Blakey? Blakey absent. Dietzen?
Yes.
Dietzen, yes. Honnold?
Yes.
Honnold, yes. Hansi? Hansi absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Let's move on to number 7.
So 7 is child prostitution, which is not a sex offense. Think about that. I mean, I think this is an interesting discussion that we've had because we talked about failure to register as a predatory offender, whether that should be on the sex offender grid. And now we have sex with a child, but because it's paid, it's not on the sex offender grid. So consistent with the crim sex changes, under 13 is changed to under 14. Sort of. They actually missed one, which I brought to the legislative attention, and hopefully they'll fix that in another special session. But for the most part, under 13 is changed to under 14. And the staff recommended response is to make no guidelines changes, thus treating the new child prostitution offenses involving 13-year-old victims like existing child prostitution offenses involving 12-year-old victims.
So are you saying it's essentially to maintain the current rankings?
Well, yeah, but by making no changes, I think by affirmatively saying this, you're acknowledging the fact that the offense has changed, the elements of the offense has changed, but you're essentially keeping the existing rankings the same.
Okay.
Notwithstanding that change.
Okay. Any discussion, or does anyone care to bring a motion?
Judge Mark, I'll make the motion
And the motion is,
to follow the staff recommended response.
okay.
Judge Larkin will second.
Judge Larkin seconds. Any discussion? Hearing none, let's go ahead and vote.
To the Mark motion to adopt the staff recommendations to make no guidelines changes in section A7. Estrada?
Yes.
Estrada, yes. Blakey? Blakey absent. Dietzen?
Yes.
Dietzen, yes. Honnold?
Yes.
Honnold, yes. Hansi? Hansi absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right, so number 8.
Okay, so number 8 is 2 things kind of rolled up in one, both having to do with child pornography. So consistent with the criminal sexual conduct changes, under 13 is changed to under 14. In addition, the commission is directed to essentially adopt the recommendations in the minority report's recommendations in the January report to the legislature, the minority report of the Minnesota Sentencing Guidelines Commission. So that would increase the ranking of dissemination of child pornography under certain enhanced circumstances, which now include child being under 14, from severity level D to severity level C. And increasing the severity of possession of child pornography enhanced from severity level F to severity level E. And the other changes are adopted. So now the recommendation is now a mandatory. The commission must re-rank use of minors in sexual performance as it proposed to do in its report to the legislature. So the staff recommended response is pretty straightforward. Adjust the use of minors in sexual performance severity levels as proposed, adjust the severity levels for enhanced dissemination possession offenses as directed, And with respect to the age threshold changes, make no guidelines changes other than conforming changes. So a case involving child pornography where the victim is age 13 would be in the future treated like a child pornography case involving a victim age 12.
This one seems fairly straightforward. Entertain a motion.
I would move approval of the staff report or staff recommended responses, which are consistent with the minority report.
Ladd
Okay.
seconds.
Commissioner Deaton makes the motion and Commissioner Ladd seconds. Any discussion? Hearing none, let's go ahead and vote.
To the Dietzen motion to adopt the staff recommendations in section A8, Estrada?
Yes.
Estrada, yes. Blakey? Blakey, absent. Dietzen?
Yes.
Dietzen, yes. Honnold?
Yes.
Honnold, yes. Hansi? Hansi, absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. Let's do number 9, and then once we're through number 9, I'd just like to take another quick break, and then we'll come back and finish this off. So number 9.
That'll be a good breaking point. All right,
Yeah.
so number 9 is that the statutory maximum penalty for solicitation of children to engage in sexual conduct is increased from 3 years to 5 years. So now it fits on the grid. It was one of those Appendix 3 offenses, and now it's no longer going to be an Appendix 3 offense. So it actually decreases the length of the sentencing guidelines, unlike most changes. So the staff recommended response is to make conforming technical changes. No ranking changes are recommended.
All right, another fairly straightforward change. I'd entertain a motion.
So moved, Larkin.
Commissioner Larkin moves. I assume you're moving to accept the staff recommendation?
Yes.
Okay, do we have a second?
I'll second.
Commissioner
Estrada.
Estrada, is that correct?
Yes.
Okay, Commissioner Estrada seconds. Any discussion? Hearing none, let's vote.
To the Estrada motion, I'm sorry, to the Larkin motion to adopt the staff recommendations in section A9. Estrada?
Yes.
Estrada, yes. Blakey? Blakey, absent. Dietzen?
Yes.
Dietzen, yes. Honnold?
Yes.
Honnold, yes. Hansi? Hansi, absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark? Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Okay, I have 4:05, 4:04, 4:05, depending on which clock I look at. So let's just take a 5-minute break. We'll come back at 4:10, and then we will get through the rest of these ranking decisions. Thanks. Okay, I'm going to call the meeting back to order. I think we are back recording. Is that correct? Or did you have a question, Nate?
Jill, you turned on the cutoff, I think, right? Like if it's off, it's broadcasting. That's how that works. Yeah, we're ready to go at any event, Madam Chair.
Okay, do we still have folks on, are the folks online back as well? Someone could give me the high sign.
Yes.
Okay. All right, moving on to the next set of changes to criminal laws.
Thank you, Madam Chair. So that completes our review of the sex offense changes. The next category is other changes to criminal offenses and sentencing policy. The First is that the creation of a new offense called child torture. So what the act does, creates a new offense for torturing a child under age 18. Torture is the intentional infliction of extreme mental anguish or extreme psychological or physical abuse when committed in an especially depraved manner. So this is intended to cover severe offenses against children that don't necessarily result in severe bodily harm, but are severely emotionally traumatizing. There's a 25-year statutory maximum penalty, so a high statutory maximum penalty, which is one of the signals the legislature gives to the commission in determining how to rank it. Staff recommendation is to rank child torture at severity level 8. An alternative is to leave it unranked and see, again, how it is ranked by judges, how severely the offense is actually committed when it's committed. I don't know that we have a lot of data on what this is going to be like. We are recommending adding it to the consecutive sentence list. The origin of the consecutive sentence list was crimes against person. This is clearly a crime against a person. And we are also recommending adding it to the severe violent offense list, although reasonable minds may disagree. I should just say severity level 8 is the severity level at which all offenses, regardless of criminal history, are presumptive commits. We did look at possibly the option of ranking it at severity level 7. I think that wouldn't necessarily be an unreasonable option either, but for purposes of our fiscal note, we assumed that the commission would rank it at severity level 8. And part of that was looking at kidnapping. There's an element of kidnapping where it involves, moving somebody from one place to another for the purpose of inflicting severe psychological harm. So it seemed to have some elements that are similar to this torture.
Commissioner Larkin.
I move that we adopt the staff recommended response of ranking child torture at severity level 8, adding it to the consecutive sentence list and adding it to the severe violent offense list.
Second.
So Commissioner Larkin makes the motion and Commissioner Dietzen seconds. Do we have any discussion? Commissioner Middlebrook.
Thank you, Madam Chair. My one concern about adding it to the severe violent offense list is that we were just talking about that and trying to figure out what our criteria would be for adding certain offenses to that. And this is such a unusual offense, and I think there's going to be such a broad range of conduct that I think we maybe should hold off on that last one just so we can determine ourselves what criteria we look at. I think the permissive consecutive, we already know we use those as crime against a person. That's pretty straightforward. But on the severe violent offense list, I think we need to look at that closer.
Thanks. I had a similar concern about that. I mean, I raised this earlier that I just don't know what the criteria is for how we determine whether something is or isn't on the severe violent offense list. And I'm hesitant to add offenses to it until we've had that discussion and figure it out. So I agree. I would agree with the first two bullets, but I disagree with the third one. At this stage, I'd like to just look into it further and then decide later. Commissioner Larkin.
I would amend my motion to add language saying we're going to reserve decision about whether to include this on the severe violent offense list pending further review and discussion. Something similar to what we used
Sure.
in the other scenario.
Okay, all right, thank you. Commissioner Dietzen, would you be, you seconded the motion. Are you comfortable with that amendment to the motion?
Yes, I am.
Okay, so the motion has been amended. Thank you, I appreciate that. Any further discussion on this motion?
Hearing none, let's take the vote.
To the Larkin motion to adopt the staff recommendations in section B1, except for the recommendation to add the offense to the severe violent offense list, instead reserving this decision on the severe violent offense list pending further review of that list. So to that Larkin motion as amended, Estrada.
Yes.
Estrada, yes. Blakey. Blakey absent. Dietzen.
Yes.
Dietzen, yes. Honnold.
Yes.
Honnold, yes. Hansi. Hansi absent. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Mark. Mark.
Yes.
Mark, yes. Middlebrook.
Yes.
Middlebrook, yes. Schnell. Schnell absent. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Let's move on to patrons of prostitution.
Thank you, Madam Chair. So right now, prostitution, just sort of the base offense, is a misdemeanor. It's a gross misdemeanor if done in a public place, I think. So this gets rid of the public place thing and just makes the base offense, elevates it from a misdemeanor to a gross misdemeanor. And but what it, for our purposes, the big change is that it establishes a felony for a second violation within 10 years of a previous conviction. So this is for repeat patrons of prostitution. It has a 5-year statutory maximum penalty. So there's currently as I said before, the other prostitution offenses are also ranked on the standard grid. So the child prostitution offense that has the same statutory maximum penalty, which involves prostitution with a child who's above the age of consent, basically, but still a child, age 16 or 17, right? Those are ranked at severity level 3. So based on that ranking, staff is also recommending ranking this new offense, which is really between 2 adults, but a repeat offense at severity level 3. I guess the defendant doesn't necessarily have to be an adult, but presumably the person who's engaging in the prostitution is an adult. So that's the staff recommendation.
Okay, any discussion, or does anyone want to bring a motion?
I'll move approval of the staff recommended response.
Commissioner Dietzen makes the motion. Do we have a second?
Larkin, second.
Commissioner Larkin seconds. Any discussion? Hearing none, please take the vote.
To the Dietzen motion to approve the staff recommendations in section B2, Estrada.
Yes.
Estrada, yes. Blakey. Blakey absent. Dietzen.
Yes.
Dietzen, yes. Honnold.
Yes.
Honnold, yes. Hansi. Hansi absent. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Mark.
Yes.
Mark, yes. Middlebrook.
Yes.
Middlebrook, yes. Schnell. Schnell absent. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. So move on to expansion of assault in the first degree.
Thank you, Madam Chair. This is known as Officer Eric Matson's law. Officer Matson was severely injured in the line of duty and suffered permanently debilitating injuries as a result. So what the act does, well, first, before we look at what the act does, let's look at what assault in the first degree is currently. So assault in the first degree, which is ranked at severity level 9, is sort of the base offense, which is most commonly committed, is inflicting great bodily harm upon anybody. Great bodily harm can be serious permanent disfigurement. It can be something that causes lasting debilitation. Removal of a body part is great bodily harm, or something that gets you close to death. It's the highest degree of bodily harm short of death in the criminal statutes. So that's the most common way of committing assault in the first degree. The other way is to use deadly force against a peace officer, prosecutor, judge, or correctional employee. And I'm shortening those 4 categories into the one-term official for the purposes of what I'm recommending in the guidelines. It just takes up a lot less space than saying peace officer, prosecutor, judge, or correctional employee. And deadly force against an official carries a 10-year mandatory minimum. So that 10-year mandatory minimum, which is a really high mandatory minimum in current law, I'll just point that out because there's some higher mandatory minimums coming down. I think when I did briefly describe this to you, I described this bill as having some eye-popping mandatory minimums. And in fact, those eye-popping mandatory minimums are now in the law. But that 10-year mandatory minimum was already there for deadly force against an official. Deadly force is kind of an unusual term. It's not the same thing as a dangerous weapon, which is what normally consists of an assault in the second degree. It's actually a term that's used when describing what force peace officers are permitted to use in the line of duty. And there are a number of requirements that they have to meet before using deadly force. And I talk a little bit about that in the paper if you're interested in details. So it's similar to use of a dangerous weapon, but not quite the same. So that's the existing law. No change to the existing law, no change to the mandatory minimums in the existing law. But there is an expansion by adding 2 new subdivisions. I shouldn't say there's no change. Some of the penalties and that sort of thing were rearranged, but the substance is the same. So the expansion adds 2 new subdivisions, subdivision 3 and 4, involving great bodily harm upon an official. And subdivision 4 also requires deadly force or a dangerous weapon. And there's these new long mandatory minimums of 15 or 25 years. So I've added this chart here on the next slide to show you sort of how this works. And I'm going into this detail because this is the first time we've talked about this. Unlike everything else we're talking about, which we talked about in either May or June or both, this time we're talking about this for the first time. So the first 2 lines show you subdivisions 1 and 2 and how that works now. And then the 3rd and 4th line show you the changed subdivisions. So we still have, so for subdivisions 3 and 4, it has to be one of these 4 officials. But whereas subdivision 2 doesn't require great bodily harm, subdivision 3 does require great bodily harm. It doesn't specify what means are used, though. It has a 15-year mandatory minimum and a 25-year statutory maximum. And the staff is recommending a severity level 10 ranking for that offense. It seems to fit severity level 10 fairly well. For the subdivision 4 offense, so that also requires great bodily harm against an official. So it's the same as subdivision 3, but it's basically subdivisions 2 and 3 combined, sort of. So you've got the means in subdivision 2 of deadly force plus an alternative means of a dangerous weapon, which is pretty similar to deadly force. And you have to have the harm in subdivision 3 and subdivision 1 of great bodily harm. So you put all that together, the official, the dangerous weapon or deadly force means, and the great bodily harm, you get a subdivision 4 offense, which has a 30-year statutory maximum and a 25-year mandatory minimum. So that's a really small window. As I point out in the report, that's within the range of a single cell on a sentencing guidelines grid, where you have to go by law 20% up and 15% down. That 25 to 30-year range is comfortably within, say, a 27-year sentence would easily have, it would go beyond the 25 years down and the 30 years up. So because of that anomaly and because of the fact that it just doesn't fit very well on the grid, we're just suggesting leaving it unranked. It's essentially the judge is going to have very little discretion anyway. They have to sentence within a 25 to 30-year range. So sort of look at this as a legislative signal to sort of shoo the Guidelines Commission out of the way. They've got this sentence taken care of. So in light of that, I'm suggesting that you just leave it unranked. So back to the staff recommended responses on the previous slide. As I said, we're recommending ranking assault, first degree great bodily harm upon an official at severity level 10. That's the subdivision 3 offense. leaving unranked assault, first degree great bodily harm upon an official by dangerous weapon or deadly force, and clarifying and editing the offenses listed at severity level 9 in the sentencing guidelines grid. That's to reflect the fact that all first degree assaults are no longer severity level 9 after this change. So you have to specify what severity level 9 offense we're talking about, or what first degree assault we're talking about here at severity level 9. And by the way, we're picking great bodily harm since that's by far the most common offense, notwithstanding all this talk about officials. And clarifying and distinguishing offenses listed in section 5 because of the new terminology, and including the new offense in appendix 1, mandatory and presumptive sentences reference table, which lists hopefully all of the mandatory and presumptive sentences contained in the statutes.
Okay, Commissioner Larkin.
Why aren't we ranking assault first degree great bodily harm upon official by dangerous weapon or deadly force at 11? It seems that that should be ranked higher than 10. Why would we leave that unranked? Can you explain that again?
Yeah, let me pull up the grid here.
Thanks, that's helpful.
Yeah. Shoot. Oh, I'm sorry. I'm gonna find it first. I just remembered to put the grid in your meeting materials, so I could have referred to that, but I went the long way. So, all right, I'm blanking out on the math here. What's 25 times 12? Okay, so 25 times 12 is 300, and 30 times 12 is 360. So we'd be looking for something in the 300 to 360 range. So at severity level 11, you'd pretty much be there in the first cell.
It's 300.
Yeah, 300 to 360 is the range we're looking for. So, I mean, it would fit at criminal history score of 0. They'd be recommending 306, which is 6 months more than mandatory minimum. So, I mean, I guess you could do that. It's just the grid becomes irrelevant very quickly once you get past 360. It's not even. I don't know. I mean, I think it wouldn't be unreasonable to rank it at severity level 11, Commissioner. I just it just seemed to me that the legislature was giving the sentencing judge so little wiggle room here that it didn't seem to make sense to even put it on the sentencing guidelines. But you could.
Any discussion or thoughts from the commission on the way to
Chair
go with
Mitchell?
this? Commissioner Larkin.
All right, as a former district court judge and as somebody who reviews these opinions, I know district court judges don't like unranked offense. It complicates things. It makes work for everybody. I get that it's not a perfect fit at 11, but conceptually, it's obviously a more serious offense than great bodily harm without dangerous weapon or deadly force. So it makes sense to rank it one above that offense. And leaving it unranked, I think sends the message that, well, we maybe don't think this is so bad, so we want to allow a district court judge to rank it, you know, somewhere other than 11, and there really is no other choice. So I would support ranking it at 11, even though you're going to phase off the line or the boxes rather quickly.
Okay. Any other thoughts on that? I mean, what do others think about this particular one? It's again, we have like a lot of things that don't fit well this year.
Yeah.
Yeah,
Trying to make the best of a bad situation.
Well, if there's no discussion, I'll move to rank it at 11.
and I would second it. I think it's the most consistent to put it at 11 rather than to unrank it.
Do you want to incorporate the other two items into your motion, or do you want to take those separately?
Could I see them again? I'll incorporate the other recommendations from staff in the motion.
Okay, and Commissioner Dietzen, are you amenable to that change?
Yes, I am.
Okay, so then the motion is to accept staff recommendations, except that the last offense will be ranked at severity level 11 instead of remaining unranked. Any discussion? Commissioner Middlebrook.
Thanks, Madam Chair. I guess I am kind of leaning towards the unranking. I have a concern that putting it at a severity level 11 with a second degree intentional murder, to me, doesn't quite fit. And I think that I understand that judges don't like the unranked offenses, but this one is a pretty obvious what the sentence is going to be with a 25-year mandatory minimum. So I guess I would say that it doesn't quite fit either a 10 or 11. So I would lean more towards an unranked, but that's my opinion.
Other discussion? I'm struggling with this one, just like I've struggled with everyone that doesn't fit today. Because I think Commissioner Middlebrook makes a good point that, you know, the type of harm is also a very important consideration in where the offense should be ranked. And so we kind of have a mismatch there when we look at the other types of offenses that are at 11. But the numbers fit, you know, so it's not clean no matter what we do. Any other discussion? Or does anyone else want to make a final pitch before we vote? All right, I think we just vote.
All right, to the Larkin motion to adopt the staff recommendations in section B3, except ranking assault in the first degree involving great bodily harm upon an official by dangerous weapon or deadly force at severity level 11. Estrada?
Yes.
I just didn't hear you, Commissioner.
Yes. Can you hear me?
Yes, I can hear you a little bit
Yes.
better. Okay, Estrada, yes. Blakey? Blakey absent. Dietzen?
Yes,
Dietzen, yes. Honold?
Yes.
Honold, yes. Hansi? Hansi absent. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right. Reorganization of drive-by shooting.
All right, so this reorganizes drive-by shooting statute to clarify that a victim doesn't have to be in another vehicle or building, which is a lot shorter way of saying it than the way I say it in your materials, but you're welcome to read those if you want. And we're just recommending making conforming technical changes. Actually, the way the guidelines describe the offense is exactly the way the state thought the offense should be described in that case that I cite there, and essentially the legislation conforms to that description. So it's just minimal technical changes, no changes to offense descriptions.
Commissioner Mark, I'll make the motion to follow staff recommended response.
All right,
Larkin seconds.
Commissioner Mark makes a motion and Commissioner Larkin seconds. Do we have any discussion? Hearing none. Let's go ahead and vote on that.
To the Mark motion to adopt the staff recommendations in section B4, Estrada.
Yes.
Estrada, yes. Blakey absent. Dietzen.
Yes.
Dietzen, yes. Hunold.
Yes.
Hunold, yes. Hansi absent. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Mark.
Yes.
Mark, yes. Middlebrook.
Yes.
Middlebrook, yes. Schnell absent. Chair Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved unanimously. And last item is the Veterans Restorative Justice Act
Wow, it is the last item.
on
All
this
right.
list.
On this list for agenda item 4. All right. So this is the Veterans Restorative Justice Act. We've kind of seen this coming a long time. It's finally been enacted. This is the only act that you're looking at that was effective August 1st instead of September 15th because it wasn't in the public safety bill. It was in a different bill. And it requires stays of adjudication when a defendant suffers from a service-connected, offense-connected condition. And it also provides, if somebody is convicted, notwithstanding that required stay of adjudication, it provides a mitigated guidelines departure factor in the event of conviction. And it has a number of criteria for that. Not all offenses qualify for the mitigated departure factor. We're recommending 2 things. One is in the section of the guidelines that lists the departure factors. We're recommending including this statutory departure factor, basically cross-referencing it. As we've drafted it, it doesn't go into exhaustive detail about all the requirements of the factor. It just essentially cross-references you to the statute. And then we're referencing the act in section 3F, which talks about military veterans. There's an existing law that requires the court to ask the defendant before sentencing whether the defendant's a military veteran. And we're also cross-referencing this in the next section, next sentence. So that's the staff recommended response.
All right, thank you. I'd entertain a motion.
Larkin moves to adopt the staff recommended response.
Okay, Larkin makes a motion. and
Middlebrook second.
Commissioner Middlebrook seconds. Do we have any discussion? Hearing none. One more time.
To the Larkin motion to adopt the staff recommendations in section B5, Estrada.
Yes.
Estrada, yes. Blakey absent. Dietzen.
Yes.
Dietzen, yes. Hunold.
Yes.
Hunold, yes. Hansi absent. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Mark, yes. Middlebrook.
Yes.
Middlebrook, yes. Schnell absent. Chair Mitchell.
Yes.
Chair Mitchell, yes.
And with that, no, I'm sorry, go ahead. Give me the count.
Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Okay, so that ends action item 4. Action item 5 is a publication of the August 1st edition of the guidelines. So let's go through that.
Yeah, so Madam Chair, I spell this out in the handout, but basically what staff would request is that the commission authorizes to skip the August 1st, 2021 edition of the Minnesota Sentencing Guidelines. Clearly, there are going to be a number of changes that are going to be effective September 15th. I lay out what my interpretation is, but what I understand that the legislature did in approving the other child pornography recommendations or proposals that the commission made in its January report to the legislature. My interpretation of that is, and to do so effective September 15th, 2021, and to apply to crimes committed on or after that date. My understanding is that the ranking changes to use of minors in sexual performance that the commission proposed back in January are not effective August 1st as they would normally be, but are instead effective September 15th. If the commission agrees with that, then basically the only things that are left are pretty inconsequential. They're really very minor changes to the sentencing guidelines or the commentary. And I just to avoid confusion, I would strongly recommend that you just skip the August 1st edition of the sentencing guidelines so that people aren't confused about what changes there were in 2021, because most of the changes, including a number of very significant changes, are going to occur on September 15th. So I'm concerned that a publisher might pick up the August 1st edition and publish it thinking that's the 2021 edition. I'm concerned that practitioners might get confused on which edition of the sentencing guidelines is the correct edition if we publish two editions within 45 days of each other. So that's the staff recommendation, that you that you allow us to skip publication of the August 1st, 2021 edition of the sentencing guidelines and commentary.
Commissioner Larkin.
Larkin moves to adopt the staff recommendation for publication in September, not August.
Okay, we have a motion. Is there a second?
Second.
We had 3 people wanting to second that. I'm going to go with Dietzen because I heard that voice first. Commissioner Dietzen seconds. Any discussion on that motion? Okay, I think we're all in agreement that that's a very good idea. Let's go ahead and do the roll call vote.
To the Larkin motion to have the next publication of the Minnesota Sentencing Guidelines and Commentary be September 15th, 2021. Estrada?
Yes.
Estrada, yes. Blakey? Blakey, absent. Dietzen?
Yes.
Dietzen, yes. Honold?
Yes.
Honold, yes. Hansi?
Absent.
Oh, Hansi, absent. Sorry. Ladd?
Yes.
Ladd, yes. Larkin?
Yes.
Larkin, yes. Mark?
Yes.
Mark, yes. Middlebrook?
Yes.
Middlebrook, yes. Schnell? Schnell, absent. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
With that, the motion is approved unanimously. I'm going to suggest item 6 is reviewing the crime laws not affecting the guidelines. And I guess I'm just wondering if instead of going through it all, if there's anything in particular that you wanted to draw our attention to, Director Wright, since everybody had an opportunity to review it, maybe we could do it that way.
Sure. I thought there are a number of task forces that involved the Minnesota Sentencing Guidelines Commission, but I didn't see any that involved appointments. It was either somebody specified, like I was specified on one of them, and then, or it was like Commissioner of Corrections has to invite somebody from the Minnesota Sentencing Guidelines, but it's really, I didn't see it as being the commission's decision. I saw it as being the convening authority's decision. We talked about the mentally incapacitated definition expanded. Let's see. The criminal sexual conduct statute of limitations repeal is significant, but that's prospective only. So it's not unlike many changes to statute of limitations. They apply to all offenses that are still alive at the time the act was passed. But this repeal is only for offenses committed on or after August or September 15th, 2021, I think. So that's going to be a little different. So that law will not have any effect for years and years to come. And it may disappoint some people who were looking to keep old offenses alive. We saw a bunch of stuff about adding to PSIs for brain injury or that kind of thing. That was all kind of boiled down into this neuropsychological examination feasibility study that the court branch is supposed to do.
Oh, I didn't even realize that's what that was related to.
Yeah, that's what
Okay.
that sometimes happens where like a policy proposal is deemed to be worthy of talking about more, but not necessarily enacting. They instituted task force. The other thing I wanted to bring your attention to is number 5, the task force on an effective supervision system. It seems like a really interesting task that the Commissioner of Corrections has been given. Just an incredibly short time frame in which to do it. He's supposed to have a report to the legislature due on December 15th. And he's supposed to convene a working group. We're not on the working group necessarily, although he can invite whoever he wants, but they have to study and report to the legislature on the attributes and requirements of an effective supervision system, to include cooperating with tribal supervision and sustainable funding proposal. I mean, it's a very comprehensive scope of the task. It's just an incredibly short time frame. So good luck, Commissioner Chanel, wherever you are.
He's probably running away from it right now.
So yeah, that's all I needed to bring to your attention.
Okay. All right. Thank you. Okay. So item 7 is the public hearing process.
Yep. So right now we're scheduled to have the public hearing in this room. We have to have our notice to the obviously there will be a public hearing. The public hearing will be on September 1st. We have to have our notice to the state register by next Tuesday. If a room in the Senate building comes open, they haven't opened up the Senate building, but if they open it up by next Tuesday, we're going to move over to the Senate building just because they have more room and a bigger screen and the same, I think, pretty good technology that we can run hybrid meetings by, but a little more room and closer bathrooms. So we'll either have the public hearing here or there, but we'll have the notice will be published a week from Monday.
Okay.
For the September 1st hearing. And a quorum is not required for that hearing, but a quorum is required for the September 9th meeting to follow.
Okay. So item 8 is the partial points in criminal history working group. So we've continued to meet and we have sort of come up with a couple of different proposals. We still have, multiple proposals on the table. Right now, we're asking staff to develop some numbers for us so that we can get a better sense of what's the impact of these ideas that we have developed. Our goal, I think, would be to bring the proposals that still seem to make sense after we've looked at those numbers to the commission for sort of the first introduction of the proposals in September, so that we can begin to work through and talk through those options this fall, with the goal, ultimately of trying to get this resolved by the end of the year, by that public hearing period in December. Does anyone else want to add something to that? Okay. I gave you a short break there. Back to the executive director's report.
Thank you. So, Madam Chair, our budget was approved. At the same time the budget was approved, the hiring freeze that's been in effect for a long time was lifted. So we've been short-staffed since January. It's really been causing our output to suffer. Hopefully not on your end. We kind of prioritize the commission, but as far as our reports, they're pretty late. Our public reports getting out and other things have suffered. So we hope to have that position posted very soon for a research analyst and hopefully hiring shortly after that. I don't know, Madam Chair, if you wanted to talk about the hybrid meeting and whether that's going to continue or whether you want us to meet in person in the future. And then the third thing I wanted to mention was that earlier today I sent out an invitation to the annual meeting of the National Association of Sentencing Commissions, which we're a member organization of. You're all welcome to attend the annual meeting. Hopefully it'll be pretty quick. And I sent out an invitation to you for that. Unfortunately, it's virtual this year, but since it's free, we can afford to send you all. So if you all want to attend the meeting, you're welcome to. Next year it'll be in Portland, Oregon, so that'll be a little more fun.
And yes, I do want to talk about meeting structure going forward. My preference would be to get us back to in-person meetings as soon as we can. I think that most places are starting to come back starting in the fall. I know I as an employee of the University of Minnesota,
we're actually not even open until August. And then by fall, we're expected to be back to normal. So I kind of wanted to get a read from the group on what your situations are as well. We could still probably do the September meeting this week, but maybe by October we could think about having in-person meetings going forward from that date. I'd just kind of be interested in reactions from folks on that front. Commissioner Larkin?
I support continuing to make remote participation an option for the commission members. I think everyone, including the Court of Appeals, is taking a look at the ways that remote participation, including for us, Zoom hearings, has benefited people, made the court more accessible to the public, to the parties. And I think on this group where you have people that are coming from distances and taking time off of work to do so, it's important to make it as convenient as possible for them, and also to make it as easy as possible for the public to watch the hearing and participate in the hearing. So I strongly support making remote participation available to the public and to the commissioners going forward post-pandemic, a mainstay of the way we do business, because I think it reflects changes that are being made everywhere.
Commissioner Ladd?
Thank you, Madam Chair. As probably the person on the commission that probably comes from the furthest location, and I'm actually here today, so glad to get out of the office. I also would support having that option, and I think that to Judge Larkin's point, I think everybody's re-examining sort of how we do business more efficiently and more effectively. That I think the legislature dealt with this when they made the modifications to these meetings for these types of bodies and how they can continue to be done remotely with different exceptions than they had in the past. And so I appreciate getting together to see people. I think sometimes it's easier to conduct business. I do agree with that. And I do like seeing people, but I recognize that things happen, something out of my control. For example, you guys might have sunny weather here and I might be getting a snowstorm up on my neck of the woods. So I just would like to have that option personally, and I know that's somewhat self-serving, but I do also agree that I think it allows some transparency for other folks to be able to attend these meetings when they otherwise wouldn't. And so I would hope that we would utilize the modifications that the legislature has made under Chapter 13, Chapter 13D, yeah, related to how we can conduct these meetings and try to be here if we can, but also recognize that we can also conduct business when we're not all together. And so I just would like us to have that option.
I think that I don't disagree with anything that's been said. I think that we are going to be limited in terms of, where it's feasible to do this. I actually, personally didn't think this was a great setup today. I didn't log in, but, because I wanted to see, how this would work. And I suppose if we did this again, that's what I would have to do, is be logged in on my computer, because it was absolutely ridiculous to try to follow it from the room. It's just not possible. The concern I have, is I don't think there's a lot of rooms that we can do this in effectively, but maybe that's not the case. I do know that once we get into the legislative session, this room will not be available to us.
Right. And actually the technology in this room that the Senate has, and they have it also in the Senate building, I agree that visually it was subpar today. And part of that is because in G3, they only have rooms displays to the side. But the audio, I mean,
Yeah,
you might take it for
great.
granted, but they invested quite a bit of money in the audio in this room, and we are magically able to hear each other. We can hear through the speakers, everybody who's talking. We can speak into our microphones and they can hear us. That is not something to take for granted. That is technology that is not present in any other facility that I know of than the Senate right now, so at least any state facility that's readily available to us. And as you point out, this will not be available to us once the session starts.
Yeah, so I mean, that may unfortunately necessitate, I mean, you know, we certainly can always post the meeting to allow, like phone is still an option. We've done it before when individuals needed to use that option, especially on days we needed quorums. It's terrible, but it does allow the meeting to happen, you know, so we can certainly do that. Yeah, I guess that, you know, what I'd like to say is, given that there is not a lot of, since there are not a lot of places where we can conduct the meeting this way with the level of technology that we have today, I'd like everyone to really try to attend in person. But I completely understand that there's going to be days that's just not possible. And I do like the fact that if we were to continue to post, you know, always put it on our agenda that somebody may be remote, that then we cover the snowstorm. And we've had meetings, I mean, not when I was on the commission, but this commission has had meetings that where the quorum has been blown by a snowstorm, you know, and they couldn't get any business done. So I do like that ability, and I do like the ability for the public to be able to remote in. So, you know, for sure, the public hearing next week is, not next week, in September 1st is exactly the way that the staff is going to be setting it up, you know, where you can be here or not. You know, maybe we continue with this hybrid setup in September, and then let's see what's available and what we can do going forward. Maybe we'll try to be more in person by October. Anything else on that front? All right. Anything else for you to report?
No, Madam Chair, that concludes my report.
All right, great. We made it. We are now up to the public input portion, so we should allow that opportunity.
Members of the public listening remotely, in a moment, your microphones will be unmuted. If you do not wish to make a comment, please remute your mic to reduce feedback. If you wish to make a comment, please state your name and the chair will call on you. I am now unmuting the microphones.
Is there anyone online who wishes to make a comment today?
Hello, Matt Majowski. Can you hear me?
Yes, I can. Please go ahead.
I just had to take the opportunity. I couldn't just say nothing.
Go for it. What would you like to say? Did you want to say anything else? Nope. Okay, he's muted now. Okay. Anyone else online who wants to make a statement today? All right. I think nobody else wishes to make a comment today. I do want to just remind the commission that we did receive one public comment in our meeting materials today. So be sure to read that. I don't think we have an action item before us on that or a request for an action item at this point, but I just want to direct your attention to the comment that was submitted. With that, I think we are done with our business today. Thank you all for hanging in there. I hoped we would get done closer to the actual originally scheduled end time, but I think we did pretty good. We had a lot of great discussion today, and I really appreciate all of the work everyone put in today. We have a good package to put out for that public hearing. So thank you. And with that, the meeting is adjourned.